and then to do the court cry.
Okay, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this special sitting of the Appeals Court. I'm Judge Milkey. With me are my colleagues, Judge Desmond and Judge Lemire, and we are your panel for the 6 cases we are hearing this morning. Our first case is 2019 P1181, Commonwealth versus GARRETT VIL. I would remind the parties that we have read the briefs. We are familiar with both the facts and the arguments, so we would ask you, to the extent possible, to cut to the chase, because 15 minutes generally is not a great deal of time. With that, I will turn the floor over to Attorney Dreschler.
Your Honor, it's Justin Dreschler for Mr. Vil. May it please the court. So, Your Honors, what I'd like to do today is start with my Rule 36 speedy trial argument, and I want to work it a little bit backwards, which I think makes sense because the Commonwealth and I actually agree about a lot in this case, or at least a handful of things in terms of what is excludable and what is not. And if the court agrees with my analysis of the Rule 13 implications, then the Commonwealth has effectively just conceded this argument. And so I want to start with why Rule 13 is important, or Massachusetts Rule of Criminal Procedure, Rule 13, is important, and why Barry is now obsolete law, essentially. And so what the Commonwealth argued in its brief is that for the 7 days after a pretrial conference, there's established by rule, 7 days after the pretrial conference, you have to file your motions that you want to be heard. And essentially anything after that 7 days is now excludable for speedy trial purposes. And it is absolutely true that that's what Barry said. That is what Barry versus Commonwealth said. It's what Rogers said. It is likewise absolutely true that that 7 days has no meaning anymore, because that 7 days only had meaning insofar as it was tied to Rule 13. So Rule 13 was very clear. It said explicitly, you've got these 7 days. That's where that's what Barry's based in. That's what Rogers is based in. In 04, as I mentioned.
So let me just interrupt you for a second. So the Commonwealth seems to concede initially that the first 7 days is excludable.
It appears so based on their brief. I don't want to speak for the Commonwealth, but yeah,
All right.
I think that's fair.
And so if we operate on that premise, when the rule was amended in 2004, that 7 days, I'm asking you, was expanded to 21 days. Do you agree with that?
I completely agree. That's the thrust of the argument.
So if the rule expanded from 7 to 21 and the Commonwealth concedes at 7 days, then it seems to me that now it's 21 days that needs to be conceded. And we look at the time following the 21 days. Do you agree with that analysis?
I agree with that, assuming you, well, okay, I just want to make sure I don't concede anything here. I absolutely agree that 21 days is the absolute minimum. I don't think there is any way of getting around that. I think that the law is clear. Rule 13 changed. 21 days is the only thing with meaning now. 7 days doesn't mean anything anymore. But what I would say is that it is my argument, despite the fact that once we get to 21, the Commonwealth can't justify the 63 days. It can only get to 61. I don't think any of the days after that are excludable either, because the defendant never filed any motions. And essentially,
but the defendant had an opportunity to file the motions, right?
He did. The defendant,
and it had an opportunity to review the materials to determine whether or not it was going to file the motions, right?
That is true.
And it didn't submit any document that said we don't intend to file any motions, did it? Did he?
Well, I would say that it didn't submit any document that they didn't intend to file any motions, but Attorney Hochberg, I think, signaled that he didn't have an intent to file any motions, because Attorney Hochberg said,
notwithstanding the signal, did he officially indicate we don't intend to file any pretrial motions?
No, what Attorney Hochberg said is, give me this date. If I don't file anything by this date, I'm waiving them. He put that on the record. That was very clear at his first appearance, which I think was January 23rd, 2018, if I'm correct. But I think the idea of this rule, the idea of the, we'll call it the Barry rule, is that you're taking up time. You're taking up the court's time when you file motions. That's the issue. You're taking up the court's time. You're taking up the Commonwealth's time. You're essentially wasting everybody's time for your own benefit.
Counsel, isn't there another consideration, though, a practical one, namely that it's not just the judge whose time is important, it's the counsel. And if I'm the ADA and I have defense counsel telling me that they're going to file a motion, then I expect there's going to be a motion, and therefore, given all the balls I have to juggle at one time, I may turn to a different case and move that along. Isn't that a fair consideration in these?
I think it's a fair consideration. I think it's a fair consideration, and I am sympathetic to that argument. What I would say is the trial date didn't get moved back, and there was nothing preventing the ADA from continuing to address this case and prepare for trial. And so I don't see the ADA as being at any sort of disadvantage because they anticipate that there might potentially be a motion that might be filed in this case. And what I would say is that there is guidance from DWIGHT. It's not clear guidance, but if you look at that appendix in DWIGHT, which I cited in my brief, you can see that they're including these days in the speedy trial calculation that are months and months and months and months after the pretrial conference. And so if it was true that you can get 21 days after the pretrial conference, and then everything after that, when you're talking about filing motions, is excluded, if that were true, then DWIGHT would have excluded those days. But when you look at DWIGHT, they don't exclude those days. And the only difference between DWIGHT and all these other cases where it was excluded is that nothing was filed in DWIGHT. That's it. So they get to the motion date, nothing's filed, and they don't exclude anything. And so what I would say is that is, I think, quite clear guidance from DWIGHT, and it's in the spirit of the Graham ruling, as we've just gone back and forth. I think it's in the spirit of the of this acquiescence and this benefit and this causing of the delay idea that's cooked into the common law, that this wouldn't count against the defendant. So I think what you're doing here is, the problem is, if you write the rule such that you set a motions filing date, and then if you don't file any motions, it's counted against you, you're discouraging attorneys from actually reviewing the case, and you're discouraging attorneys from acting in good faith. I think you're here.
Is that true? I'm going to interrupt you there. Is that true? Why wouldn't they be able to analyze the case and then submit a document indicating we don't intend on filing any motions?
Well, that would certainly.
I think that answers the question that you're kind of alluding to, which is, I don't think the defendant gets to have it both ways. So if he's not going to file any motions and doesn't want the time to count, then submit a document that says we don't intend to file any motions. And I think you have a stronger argument. Do you agree that the Commonwealth didn't move for any continuances?
We think about that for a second, Your Honor. I think the answer is yes, but let me just hold for a second here. Yes, I agree that the Commonwealth didn't move for any continuances in this case. That I can recall in the moment. I'll submit a 16L or something along those lines if I'm wrong about that. But I feel pretty confident the Commonwealth didn't move for any continuances. This case really chugged along, I have to say. This case chugged along like a case normally would and one might expect. And it was subject to continuances that sometimes were beyond people's control, but Rule 36 doesn't care. That's the thing. After Graham and DeRico, and actually to a lesser extent Dennehy, really Dennehy started the domino effect, and then Davis clarified these court congestions, and then we have Graham and DeRico, and Rule 36 just doesn't care.
The rule doesn't care, but Graham certainly takes it into effect, right? Graham says, well, the government couldn't find the witness, and these are murder trial, and because of the weighing the balance of interests, they were trying to find. So Graham said that 1 week, at least with respect to Graham, 4 days, whatever, didn't count.
Sure. Yeah. And I think Graham said that, though, because it fit pretty explicitly within 36(2)(b)(f) or 36(2)(f) exception, 36(b)(2)(f) exception for or B2B exception related to continuances related to not being able to find witnesses. And yeah, so I think it fits squarely within an exception there. And I just don't think we have the 36B exceptions here. I also, as I've argued in my brief, I think the Commonwealth has quite clearly waived any reliance on 36B2.
Let me just ask you a question on that, because the ordinary rule is we can affirm on any ground supported by the record. The Commonwealth won below on Rule 36. So how did they, in this context, waive it?
I'm sorry, Your Honor, the Commonwealth, you cut out a little bit. The Commonwealth won on Rule 36, did you say?
Below.
Yes, the Commonwealth won on Rule 36 insofar as the court had to make a ruling because the speedy trial motion was based in Rule 36. But all of the Rule 36 has two prongs. It has the common law prong and the statutory.
No, I understand that, but why, since we can affirm on any ground, raised or not, why does that matter where the Commonwealth prevailed below? In Graham, the Commonwealth lost. So the waiver issue has to be seen in that context.
Mm-hmm. I suppose so, Your Honor. Well, I mean, I guess what I would say to that is I think Graham was clear that regardless of how they won below, if they didn't argue the 36B exceptions, then they're waived. I mean, the language of Graham is very clear. I think I have it written down. Because the Commonwealth did not specifically argue for these exclusions, most of these exclusions have been waived. And the Graham court only made an exception because they effectively argued for it. And the trial judge just foreclosed the argument. The trial judge said, no, it's not a continuance. I'm sorry, it's not a continuance. And then the appeals court, or in this case, the SJC said, come on, a continuance is a continuance. Like you can't just call something not a continuance and get around the rule. And so at the end of the day, I think the Commonwealth was given a little bit of leeway there because they tried. And in this case, they didn't try. If you look through all their filings, if you look through their arguments, they just don't invoke the delineated exceptions. They don't. If they did, sure, go ahead, like ding Mr. Vil for filing motions, do whatever you want to do. But they didn't, and so they've waived them. Also, what I would say, Your Honor, is it actually doesn't even matter, because even if you charge Mr. Vil with every possible thing you can charge him for under 36B, they still don't get there.
They're still 2 days short.
They sure are. So there's just no, I don't see it, Your Honor. I am interested in hearing the Commonwealth's argument today because I've looked up and down through this case. I can't find the 2 days, Your Honor.
So let me ask you a question with respect to your your argument based on the amendment to Rule 13. Let's say hypothetically we agree with you, but let's also say hypothetically that we think it is understandable that the Commonwealth missed this subtle point in terms of the ramifications of the amendment to Rule 13. Does the fact that you are correct in terms of how these pieces fit together end the matter, or is it possible to envision a ruling that says going forward, we're going to interpret the rule this way, but given how understandable it was that the Commonwealth missed this point, we're not going to apply it in this particular case?
Well, what I would say is the law is the law, and the law as existed at the time of the motion to dismiss was as it was. Are you asking me? I guess I'm not quite sure you're asking. Are you asking me if the Commonwealth should be forced to lose because they've conceded the rest of these days? The answer to that,
no, that's not what I'm asking you. I'm just trying to say if there is any room to affirm here if we agree with your your argument based on the amendment to Rule 13. Does that end the case, or given the, if you will, confusion about the implications of this, that it would be unfair to the Commonwealth to adopt this interpretation as to apply in this case? That was inarticulate, but I think you understand.
I got it. No, I think the Commonwealth is completely bound by it. I don't think there's any way that the Commonwealth can get around these extra 14 days twice. So the 28 days. I understand. Like, Your Honor, I had to do a deep dive on this. It's not as if, I'm in the reporter's notes, I'm in the amended versions, but that's what lawyers do, right? I think we get things wrong all the time and we have to correct them. And the law in place at the time said a certain thing. And just because nothing had gotten to the SJ, the only reason this hasn't been corrected, Your Honor, the only reason this hasn't gotten here before is because there just aren't a lot of speedy trial cases that come before this court or the SJC. It just doesn't happen. There just aren't a lot of Rule 36 cases.
If you prevail, there may be more.
There sure may be. And I have to tell you, I'm pretty shocked. Since we only have 45 seconds here, anecdotally, when Graham and Dennehy and Dorico came down, I can't believe that hundreds, if not thousands of cases weren't immediately dismissed in the district and municipal courts. It still shocks me to this day that we aren't litigating these things constantly. But the fact is, this is the law. It's been the law for a long time, and the Commonwealth's bound by it. Judge Desmond, I see that you have Judge Lemire, Justice Lemire, if you will.
You raised the Rule 13 issue in your reply brief for the first time, correct?
Mm-hmm.
Is there any waiver issues there?
I don't see that there are any waiver issues because I raised the argument essentially here is Rule 36, and the Rule 13 argument is just a reply to the Commonwealth's incorrect interpretation of something. I was just correcting what the Commonwealth did, but the gist of the argument is the same. With that, with no other questions, I will rest, citing Rule 22. I found this argument to be particularly interesting, so I won't address the other ones. Justice Milkey.
Okay. I need to check with my panelists to see if they have any follow-up questions.
Sure.
Well, the Commonwealth concedes that their number count was wrong below, right?
Yes, quite. I'm sure you can ask Ms. McGrath that, but I think the work below needed a lot of corrections, I think.
I will ask them. Thanks.
Okay. Thank you.
Thank you, Your Honors.
Thank you very much. You'll hear from the Commonwealth, and please unmute yourself, Attorney McGrath.
Good morning, Your Honors. My name is Jocelyn McGrath, and I represent the Commonwealth. I think we have to at least touch on the reasonableness of applying the, I guess what we're calling the Berry Rule forward, because it's been cited in at least 6 significant cases past the point of the procedural amendment. But I would also like to say that in general, this docket is pretty deep, and we have also examined it very carefully. And this defendant did receive a speedy trial, and the idea that he did not receive a speedy trial is contrary to the facts in the record.
Well, let's hone in. We agree that he wasn't tried within 12 months. Let's just start there, right?
Yeah. Well, he triggered a speedy trial.
Was he tried within 12 months?
He triggered a speedy trial.
Hold on. My question calls for a yes or no comment. So from the date of his arraignment, was he tried within 12 months? Yes or no?
He was not. He was tried within 15 months.
Okay.
Correct.
So Rule 36 calls for 12 months, unless there are some excludable dates. I mean, we're working on the same law here. We agree with that?
Yes, we are, Your Honor.
Okay. And so you agree in your papers earlier that Rule 13 allowed 7 days, and you calculated the 7 days. Is that fair to say?
Yes, Your Honor.
All right. And so when the rule was amended to 21 days, how does the calculation differ?
Well, the calculation would differ in that the period of extension would be decreased, and therefore the acquiescence would be decreased. The days of acquiescence would be decreased. Basically, the base calculation goes through what is allowed by rule. So if the rule allows up to 7 days past the pretrial conference, and then that's the base calculation. Anything beyond that is acquiesced. So our period of acquiescence was decreased when the rule went to 21 days for a defendant to file motions.
So that means you have to make up 28 days. Is that right? Because there were 2 pretrials that were pushed back by 14 days.
Your Honor, I believe we are off by 2 days, but you have the power to look at this docket, and you actually are able to go into the docket. And if you can see that there's another exclusion or days that are excludable, you may exclude them.
Right, but could you find them? I mean, I understand
actually,
that. That's your job.
Yeah, that's my job. And we did not raise this in our brief. It's not easy to point this out directly, but if I can turn your attention to the docket for September and July.
Hang on one sec, please.
Yes.
Go ahead.
So basically, there's a co-defendant in this case, and the hearing court actually pointed this out, that there are reasonable delays that are related to having a co-defendant. So the co-defendant in this case, Carrie McIntosh, in July and August, she put protective orders out for certain days in those trial months. So basically, those days, because he is bound by his co-defendant, are acquiesced to. And so I would like you to examine the protective orders that are found on the docket in July and in September, because they form the basis for another period of exclusion.
Hold on, I just want to follow along here. Are you talking about paper number 2?
In the defendant's record appendix, the docket for Carrie McIntosh is on 76 to 77.
All right.
And there are protected days. She put out protective orders for certain days. Those days would not be available for trial. And because she and the defendant are bound, that's constituting acquiescence, and those days can be excluded.
That was the Commonwealth motion.
No, well, if you go to her docket, you see that she actually has two motions as well. We have some motions. We are not claiming those as acquiescence, but they also do show that the availability of September dates was really quite limited. And it also shows that the Commonwealth was fulfilling its obligation to prepare for trial. But if we're just talking about acquiesced days, yes, we did find 5 more days. Some of them are overlapping, but 5 are not.
September, you say?
July and
entry.
September.
I'm looking at an entry of August 21st on Record Appendix 76. It says defendant's motion for protective order for 9/17, 9/19, 9/24, and 9/25. Is that what you're talking about?
It's in my record in 2 different places. So let me.
All right, I see it at 6/27, defendant's motion for protective order from trial.
Yes, and 8/21.
Yeah, and you're focusing on 8/21.
Well, they would both count. Oh no, actually they wouldn't. Let's see, 8. Commonwealth.
And as you all are scrutinizing that specific issue, I just want to raise a generic point, and that is the Commonwealth obviously is raising a new argument here to which the defendant has not had an opportunity to respond. I understand that the need for this new argument may have been occasioned by an argument raised for the first time in the defendant's reply brief. For obvious reasons, it is possible that the panel at the conclusion of this hearing decides it wants supplemental briefing on this issue. If we do, we will invite that briefing. We don't want the parties to submit documents otherwise, couched as a Rule 16 letter or something else. So I'm just putting this out on the table.
I guess I would just want to point out that this court has the power to go to the prima facie evidence, could decide on the docket. And
no, I certainly understand that, but power and discretion are 2 different things.
I understand, Your Honor.
In Graham, the court found some days, and it seemed that they found some days primarily or in large part because they were murder trials. We don't have that here, right?
No, we don't. I mean, are you referring to the waiver issue? I'm sorry, Your Honor.
Well, I'm referring generally speaking to, yes, the analysis when weighing the interests.
The analysis when weighing the interests in terms
of the defendant's right to a speedy trial and the government, right?
Yes. And
Go ahead.
I guess I'm trying to narrow the question down to something that I can understand and answer.
Well, let me ask you this. Let me ask it in a different way. Do you think that this case squares on all fours with Graham?
Absolutely. I mean, I think really Graham is interesting because it really did say, look, scheduled dates you can't acquiesce to something that's scheduled and hasn't been delayed. Our case actually went forward with very little delay. And I think, and all the obligations were, everyone fulfilled their obligations. The defendant actually used the Rule 36 in order to trigger a speedy trial. I mean, this could actually be seen as a successful use of a Rule 36. I don't think the waiver issue is significant, but I do think that Graham actually wants sort of a stringent application of making sure that the Commonwealth isn't sitting and letting defendants, sit on a trial list. I think they really would prefer that things get moved along, and that everyone's obligation is in good faith is to move it along. I'm not sure why it wouldn't square with Graham.
Well, I thought that the Judge Gant made a factor was that the nature of the case, and in that case, it was a murder case. I thought he said that explicitly.
Well, I think Graham is very specific on its own facts. This is a very bare bone case. I mean, like, he really felt that it would be an injustice to not be able to reach the issue of the witness not being that the witness, that the Commonwealth had somehow done something wrong, but that's not the case here. This is very clean. It's a clean case. There's no bad faith. No one's raised anything about bad faith. Everything went according to plan. It went according to the tracking. So perhaps in that sense, this is really doesn't even hit some of these intense factors.
Does Rule 36 mention bad faith? If so, point that out to me, because I missed that.
I think that when you review the case law, the cases where there's long periods of time where no one does anything, that raises the court's interest. If you can actually, and courts will actually mention when the Commonwealth and the defendant basically share a basic understanding of the record. It does matter.
I understand, but my question was a little more pointed. My question was, does Rule 36 address bad faith?
No, it does not.
Okay.
So just so I'm clear, in response to the reply brief and the 21 days, are you agreeing the 21 days apply, and in the previous calculation that would throw you off by about 2 days?
I think there's a very strong argument that the amendment of the rule did shift the basis for how you would count acquiescence. I don't think there's any way around that. But I think
in response, you're suggesting I did a deeper dive as a result of that reply brief, because it was the first time I was aware of it. And as a result, I found these other dates that are excludable because of the protective orders in the co-defendant's case.
That's a fair assessment. I think you could also there's a fair argument to say that it would be proper to apply the law going forward that's been basically in place for 40 years, especially.
But if we accept your argument about the excludable dates on the protective order, there's no need for us to do that. You're suggesting the protective orders give you the sufficient number of days that you had them tried within the Rule 36 calculations.
I stand on everything in the Commonwealth's brief, but this court has options to craft.
Listen, it would be more helpful if you would just answer questions directly, and then if you wanted to explain the answer, that's fine.
Yes, Your Honor.
But it would be more helpful if you would just answer the question directly. So the question is, the 5 days that you found relative to the protective order, are you saying that gives you at least another 3 days beyond the 2 days that you needed? Is that your position you're taking today?
If this court decides to address the amendment in the rule, yes. In this case, yes.
Well, you have an argument as to why we shouldn't address the amendment?
I think the argument is just that it's been applied very consistently for 40 years. In published cases, the SJC has cited to it positively. In 2018, this court cited to it in a published case. 2017. It's really been a part of the jurisprudence for a long time. So,
but to all the, I mean, I looked at some of the history after the rule, and it looked like some of the cases actually dated back prior to the amendment. So are you suggesting, and are you suggesting that all the cases that have been citing the Rogers type standard, or at least some of them, the trials occurred after 2004?
That's correct. And the periods of arraignment, the actual periods that would have to be considered, happened after 2004. I sort of sifted through it carefully. So there's at least 6 cases that I've cited to either Rogers or Barry, absolutely verbatim, starting in 2008, all the way through to 2018, and there's SJC case that cites to it positively. Commonwealth v. Davis, this is a published case out of this court that's really instructional. So basically, like it has got pulled through several cases, not insignificant cases. So I guess there is an argument to that it would be reasonable to apply it in this case as something that no one caught, and it took a long time, and it's a good catch, but it has actually settled into our law in a very significant way.
The defendant is still incarcerated today, is that right?
No, he is not. As far as I'm aware, he was released at the end of October. So we're really, the issue is whether his indictments will be dismissed and his record will be cleared.
And I didn't see his record in the papers, not that they touch on this, but is his query in the record?
Not that I'm aware of.
Okay.
Well, it wouldn't be expunged, it would just be dismissed.
It would be dismissed. But it's significant. He got a fair trial. He requested a speedy trial. He got one. He got the benefit of the speedy trial. I mean, it's a misuse of the rule then to be able to turn around and say, I didn't get a speedy trial. I'm dissatisfied with the trial I got because it wasn't fast enough. I mean, really, there are a lot of other defendants. I see my time's up.
Yeah, I'm not sure you wanted to complete that sentence anyway.
No, really didn't.
Yeah. Do either of my colleagues have any follow-up questions?
Very interesting.
Thank you. Interesting case.
Very interesting case. Again, if we feel that supplemental briefing is required, we are likely to issue an order to that effect quite soon. So.
We are live and recording.
Thank you very much. We are back on the record in our second case of the morning, 2020 P 1336, Commonwealth versus Meyer. We would remind the parties that we have read the briefs, so we are familiar with both the facts and the legal arguments. So since 15 minutes is generally not a great deal of time, we urge both sides to cut to the chase to the extent possible. With that, I will turn the floor over to Attorney Benyon.
To the presiding justice, and may it please the court. So I've raised 3 issues in my argument. I'll just run through them one by one. The first issue is the retroactivity of Felice. I'm not aware, as I shepherdized the cases in preparation for this argument, I didn't see a case published that announced that Felice is retroactive. Although there is one published opinion I saw from this court from back in August, where neither party even identified it. In this case, the Commonwealth argued that Felice is not retroactive. The trial judge who heard the motion seems to have just ignored and passed over that argument. And I want to raise it because I think it's important because.
Okay, counsel, why should we reach this issue when there was a hearing on the issue? So your client got essentially what he asked for.
That's a good question. My sense is that this has to do with the standard of review that a court is going to put on this. In other words, if we're looking at a case, and I'm going to just go over the standards for retroactivity. If we're talking about a constitutional new announcement of a rule that is applicable, then when we review the reasonableness of Felice, which gives a reasonable determination, that's going to be reviewed de novo by this court, and that's the standard that Felice itself has is de novo. And so I don't want a very high standard of review like miscarriage of justice. I want de novo, and so it's very helpful to me to have this court understand Felice as a new rule that is retroactively applicable. In that case, it's going to be a de novo standard of review and nothing higher. Does that answer the question?
It responds to the question. I'm not sure I understand your argument that the review would be de novo.
So in some of the unpublished decisions that I've seen, just because the defendant didn't raise it when he was sentenced, the court gives a much higher standard of review. It's not de novo. For example, some of the unpublished decisions I've seen show that it's substantial risk of a miscarriage of justice, and I don't think that's appropriate.
So I'm going to ask you, one, can we talk about published decisions?
There is no published decision that says Felice is retroactive. All we have is Felice.
Okay, and so you say that based on the standard of review, you would prevail under de novo standard, but you have a bigger challenge under substantial risk.
No, I think
Or you saying
no, I don't like
going forward.
So I'm an appellate lawyer. I don't like substantial risk of miscarriage of justice. It leaves a bad taste in my mouth, but I still think I think I can still win under that higher standard because, again, Felice announces a constitutional rule under Article 14 that sets out a standard for the government to show why GPS is necessary. Okay, it has to be particularized to the defendant.
Didn't that happen in this case? Wasn't there a hearing that talked about why this particular defendant should have GPS? Isn't that what Judge Tupman heard?
A hearing took place, and I included the transcript. And as you read from the transcript, there was, and you also have the government's opposition to my client's motion. There is no particularized issue. As far as I can tell, all the government raised was, or the government's point was, he could do this again, and therefore he should have GPS. And all the lower court judge did, as far as I can tell, is parrot the standard in Felice and say that it was met. But I'm not sure that it was, because if you look at this case, the defendant laid out, pro se, he laid out why GPS is not appropriate for him. And I don't think that it is reasonable for the court to have attached GPS to the probation conditions.
Well, he says, I mean, really? So we're going to look at the reasons he advocates why he doesn't need it?
Well, it's the government's burden. And you have the government's motion, and they didn't say anything other than the fact that he could do this again. But
well,
they
said a lot more than that. Right.
Didn't the court say to protect this victim and other similar, or my words, maybe not precisely, other similarly situated?
You're right. So first of all, the daughter in this case, the victim, has grown up. She's older than 26 now, and when this occurred, she was a minor. Also, this kind of gets into the second issue that I raise, and that is this defendant went pro se because he didn't have any other choice. So as he's proceeding pro se, he's continually writing to CPCS, requesting an attorney. He's continually requesting the court to appoint him an attorney. And this is where the hearing breaks down, because a good, competent lawyer could have made much better arguments for this defendant. For example, recidivism rates, which are discussed in Felice and Johnson, show, and I've done a number of SDP cases, so I'm familiar with the social science on this. I'm sure you've heard a whole bunch of SDP appeals, and you're probably familiar with the same social science. And when you have incest with one victim, that is the lowest. I mean, we're talking about a recidivism rate of what's generally termed around 10%, but usually lower, around 4 to 6%.
I'm going to interrupt you for a minute. Isn't there some facts in the record that suggest that he was arguably grooming the younger sister, leaving pornographic materials around the house? When the victim made some comments to the father about potentially raping the younger sister, he said, well, it's really not that bad. I mean, you didn't find it that bad. Isn't that in the record? That
is, as I provided it to you.
And there was also some threats made. I mean, he advocates, well, I'm a responsible guy. I've got a firearms license and I've got a CDL license, and that makes me a responsible guy, and you should consider that. Those are the arguments that you were referring to that he made?
Well, those are some of the arguments. Again, what we have here is a pro se defendant and an experienced attorney who understands, for example, how to argue recidivism rates with respect to this particular client. Could have done more to show that he was not a big risk for doing this again. He has been on GPS, has had no problems since he was released. He began probation immediately upon being sentenced and has had no problems with probation. His record is pretty much, this is the main offense. And so when you start—
Was he classified under SORB?
I'm sorry, say that again?
Was he classified under SORB?
He would have been. I'm not sure what the classification was, though.
No, you're just bringing in different things from outside. I was wondering if SORB was.
No, I mean, so I'm looking at the standards that Felice is supposed to look at, and recidivism is one of them. Recidivism rates. This defendant has not been diagnosed with anything that would cause him to, or would cause concern that he's going to go out and commit this crime again. While I understand that, you can always fashion probation to include, and in this case it was, he has to stay away from other children. In this case, what we're squarely looking at is whether GPS is going to further the government's interest. Here you have the victim who is an adult. He has no problems with other children. He's been on GPS for or since he was released, and there hasn't been an issue. If you read the hearing, this was just a very quick parroting of Felice standards. Nothing is particularized to this individual that I can see. And this court should review to determine that a hearing really wasn't held very well. And
if a hearing was held, wouldn't it be reviewed, assuming no waiver issues, at most for an abuse of discretion?
Well, as I look at reasonableness, reasonableness would be determined de novo, because you're going to look at the same standards that the court used. Now, any facts that are found—
we generally don't do that. We defer to the trial court judge on these kinds of discretionary—
Understood, but here you have a constitutional right to be free from unreasonable searches, which Felice found that in order to put a GPS monitor on a probationer, the court has to look at first of all, it's the government's burden, and the government has to show that GPS monitoring furthers its interests. In this case, there's no issue as to why it would. The government didn't make any great argument as to why it would, other than the fact that he could do it again. And that is not in itself enough to meet the standard. The government also must show particularized reasons for this individual. Again, this is not somebody who has, as in other cases, has raped multiple children over long periods of time. In that case, yeah, you're going to want to keep a very close eye on such an individual. And I understand that. But in this case, where you have only one victim, He pled guilty. He's been a model. He was a model inmate. He's been a good probationer. He has probation that's still hanging over him that could result in more prison time, which he understands. There's just no reason for this individual to be placed on GPS.
Counsel, I want to ask you one question about the issue of retroactivity.
Sure.
I don't believe either side has cited it, but a few months after Felice, there was a decision by the SJC in the SORB context, specifically John Doe 496501. The issue there has, even albeit in the SORB context, has a lot of parallels to the issue in Felice, namely, could SORB disseminate the information about a level 2 or higher sex offender on the internet? And the SJC held that yes, SORB had to make an individualized determination. They couldn't just apply this on a blanket basis to all level 2 and 3 offenders. Unlike Felice, and keep in mind this case came out a few months after, the SJC expressly addressed the retroactivity issue in a something of a middle ground way, where they said that the rule established by this case, even though it was interpreting an existing statute, applied prospectively only, with the qualification that an appellate court in its discretion could apply it retroactively and remand for a determination. And it said that the line, well, they at least strongly suggested that the line that was being drawn was contact versus non-contact offenses. That is, an appellate court might want to remand non-contact sex offenses for an individual determination, but there's at least a strong suggestion that if it's a contact offense, there's really no need to remand, on the theory that SORB presumably would require dissemination on the internet in that context anyway. I understand you may or may not be familiar with this particular case, but based on what I have recounted, how would you compare the Felice context to that?
So I look at what the SJC did in Felice, and I look at the court cases that talk about whether something is retroactive. All right, in this case, retroactivity applies if it places a certain conduct beyond the reach of criminal law, or it announces some sort of a watershed rule. In this case, I think we can all agree that Felice is pretty big. It announced a new rule. It set up a constitutional right. And that's the point that I want to make, is this is a constitutional right. This is not the SJC using their superintendent's power, in which case they can determine whether, in that case, if the SJC is using their superintendent's power, they can determine whether something is, can I just finish my thought?
Yes, of course. But as you do that, I would note that in the SORB case I just cited, it was not a question of superintendent's power. It's a question.
That's right. It's not. It's a question.
No, it was not there. It was interpreting the statute.
No, I understand that. But what I'm saying is that the case law is clear that when the SJC announces a constitutional new rule, it's that addresses the constitutional determination prohibiting certain category of punishment from a class of defendants because of their status or offense. That's constitutional. That's retroactive. The SJC, as far as I know, doesn't get to determine whether it's retroactive or not, because we're talking about a constitutional right, Article 14 right. Are there any other questions that
let me check with my panelists.
Yeah, I have another question.
All right.
For one, It seemed I heard you say earlier in your argument that you conceded that there was a hearing on this issue. And then I think you said, well, it wasn't a very good hearing and a better lawyer could have done a more robust hearing, but I think I heard you concede that there was a hearing on this issue. Is that right?
There was a hearing where the judge undertook the matter, but what I want you to look at is the point where, and this is the second argument, where the client specifically said he had asked for a lawyer. And
I know, but I'm not talking about the request for a lawyer. I'm asking, was there a hearing on whether or not GPS should be applied to your client?
Yes.
Okay. And that was a particularized hearing as to him.
No, that's what my point is.
It didn't result in that, is your argument, but that's what the hearing was for, right?
It was for him. I mean, it wasn't a class hearing. That's
and it was
true.
and it was for the GPS issue.
That's true.
Okay. Hearing no more questions, thank you very much. We will hear from the Commonwealth. And please unmute.
You're still muted.
No need to panic.
I've been.
Thank you. I apologize. I apologize, Your Honors. May it please the court, Karen Palumbo for the Commonwealth. The defendant in this case did have a hearing before the motion judge, and the judge denied the defendant's motion, holding that given the facts and circumstances of this case, GPS monitoring is necessary to ensure that the defendant does not contact the victim and refrains from unsupervised contact with other children. The defendant in his motion before the trial court and his brief mentions no facts of the case of the underlying rapes and assaults. This court did say that they were familiar with the facts of the case. However, I think the facts of this case are particularly relevant to the imposition of GPS and the Commonwealth's concern for the safety of the victim and other children. The defendant sexually assaulted and raped his biological daughter for a period of 2.5 years while she lived in the home with him. The sexual assaults began when she was 14 years of age. And if it's too graphic and you don't want me to say this, I understand. But
well, counsel, it's not so much a matter of propriety as it is the fact that we understand the points you're making. As
okay, well,
all sex crimes are bad. The facts of this case are particularly bad.
Particularly bad. Well, I would suggest after the first sexual assault, the morning after that, the defendant asked the victim, or he stated to the victim, I really enjoyed that. I think we should do that more often. Thereafter that night, the defendant actually vaginally raped the victim. He had the victim watch pornography as a prelude to sexual intercourse. He raped the victim vaginally, anally, orally, digitally, and he inserted a glass item into her vagina. The defendant also took the victim to Bolivia to meet a stripper and had sex while they were in Bolivia. The victim was in fear of the defendant, who had a mood disorder. The defendant carried a handgun and had numerous weapons at his house. And he told the victim that he would, if she told anybody, he would kill her and he would kill himself.
Did all of this come out in the hearing, Attorney Palumbo?
The plea transcript was attached with all of the police reports. They didn't go over the facts in the hearing. The facts weren't read into the record at the hearing, but the judge was aware of the facts of the case. And I believe that she said, given the facts and circumstances of this particular case. So I think the facts are particularly relevant. And again, the court already noted that the defendant had started grooming the younger sister. And when a search warrant was executed at the premises, they did find pornographic videos and magazines and materials. And again, this court noted this, but when the victim asked the defendant not to touch his sister, he responded, why? It wasn't that bad for you. Also at the—
Can I interrupt again?
Yes.
we're familiar with the facts. The issue of retroactivity, in light of the fact that there was a hearing and a ruling that applied the Feliz decision to this case, why is retroactivity even a live issue here?
I don't think it is a live issue. The defendant received the only remedy that Feliz provides, which is an individualized determination of the reasonableness of GPS. So the court does not need to reach that issue in order to make a decision on this particular case.
And in light of that, wouldn't the standard of review be abuse of discretion?
Normally, I would say so, but in Commonwealth v. Torres, the court, it's an unpublished decision, but the court stated that the denial was based upon constitutional determination. So this court, or the appeals court, reviews independently the motion judge's application of the constitutional principles. So I believe that is the standard of review, which I noted in my brief for the court. At the plea hearing.
And just one other, other than the defendant's comment at the end of the hearing that he had requested a lawyer, was there anything on the record indicating that he had requested a lawyer for this hearing or objected to the hearing?
No, the record indicates, and I included 2 letters which were sent to the defendant from CPS prior to filing of this motion in 2017 and 2018. He requested CPS appoint something. The court forwarded the materials. CPS reviewed the materials and sent letters back saying CPS is declining to appoint counsel in this case. He twice requested it and twice was denied. At the time he filed this motion, which was July of 2020, there's no notation on the docket that he requested counsel, and there's no information such as a letter that the defendant wrote to CPS that he included with the motion to suggest that he actually requested counsel. He wrote the motion, filed it pro se, and proceeded pro se. So
and he didn't raise it in the motion to reconsider either, did he?
I don't believe so, no. And he raised it at the end of the motion too, but he never requested counsel, and I believe he knew he was proceeding pro se as he wasn't entitled to counsel at this juncture.
All right.
At the plea hearing, the judge, this is a transcript at 26, I'm at 17 and 18. He asked the defendant, once the victim was 16 years old, did you have intercourse? Yes. A number of other questions. And then the judge asked the defendant, when those events happened above the age of 16, did she express to you any willingness to do this or any consent verbally? And the defendant responded, yes. The judge responded, she did. She said, oh, this is okay, Dad. This is a good thing to do. And the defendant responded, no. Notably at the sentencing, the court imposed the condition that the defendant not minimize his behavior in sex offender treatment. And the court went on to say, if the probation department starts getting reports that you are telling counselors or doctors that something other than what you told me today happened, you'll be violating probation and I will sentence you to a higher sentence. You're not to go out into treatment and say, I pled guilty because it was the easiest thing to do. These things never happened. You're not to go into treatment and say, well, we were just hugging and kissing. I really didn't insert anything anywhere. That condition was later vacated as unconstitutional, but clearly the judge was concerned with the defendant's unwillingness to acknowledge his actions and the gravity of his actions. And when the GPS was originally imposed, yes, it was mandatory per the statute, but the Commonwealth specifically asked the court that GPS monitoring be imposed. The court said, well, it's mandatory. And the prosecutor said, if the court orders it, we'll have an additional safeguard. The Commonwealth was concerned regarding the victim, the 2 other biological daughters, which were younger than this victim, and the mother and any other victims. Also, during the pendency of this case, the defendant was charged with 7 counts of violation of an abuse prevention order and 5 counts of intimidation of witness. Those charges were, as a result of this plea deal, null prost. And although the defendant said he never violated terms of probation while he was incarcerated, he did send a letter to the victim's mother while he was incarcerated in direct violation of the court's no contact order. And again,
Counsel, were these facts before the motion judge?
They're in the Commonwealth's memorandum. Yes, Your Honor. Again, the defendant asserts that he had led a responsible life and he had no infractions prior to this. In the defendant's brief, he also states that the victim's now reached majority and is now an adult and is capable of contacting authorities if the defendant were to in any way harass her. It's clear that the defendant does not understand the gravity of his offenses, the harm he has done, the life sentence he has imposed upon his daughter, and the GPS monitoring is necessary in order to ensure that the defendant does not contact this victim and does not harm any other children.
So we could say that about any horrendous rape of a child. So the question I have for you is whether or not, notwithstanding all of those facts, is the judge's decision in this case particularized enough? Is this enough, her decision?
I believe it is, but
Which doesn't speak specifically to the facts or to this particular defendant or to the geographic proximity of other victims or the such of the like.
I mean, if the court finds that that is not sufficient, if the court needed to make specific finding of facts, either could ask the court to do so or it could remand it for further evidentiary hearing. But I believe that the facts and circumstances were presented to the motion judge, and the motion judge relied on those facts and circumstances in denying the defendant's motion to vacate the GPS. And so I believe it was sufficient.
Wasn't there some information in the record or facts in the record that the defendant was actually beyond taking the victim to Bolivia, but raping her at various truck stops while he was working?
Yes, he was, Your Honor. And if the court has no further questions,
I wondered if you wanted to comment on the analogy I was drawing to the Sorb case and what we are to make of the fact that the SJC in that case very specifically laid out the rules of retroactivity, but did not do so in this case. Does that mean it didn't intend to follow the same rules, or did it mean the SJC thought about the context in a very, I should say, thought about the issues in a very analogous context and came up with retroactivity rules that we should follow?
I believe the SJC simply hasn't addressed it, but in regards to the Sorb case, one thing I will say that I think is very important is that spoke about retroactivity with respect to contact offenses. And in this case, we have all contact offenses. It may be one victim, but it was one victim who was completely under the defendant's control and was victimized on a daily basis.
Okay, do either of my colleagues have any follow-up questions? Seeing none, I think you were about to submit on the brief.
Yes, and ask the court affirm the motion judge's denial of the defendant's motion.
I just wanted to make sure.
Thank you, Your Honors.
Yeah, thank you both very much.
We're live and recording.
Thank you very much. We are back on the record in 2021 P492, Commonwealth versus Travon, CYERE. My apologies if I mispronounced the last name. I would remind the parties that we have read the brief, so we are familiar both with the facts and with the arguments. So we urge you to the extent possible to cut to the chase. And with that, I will turn the floor over to Attorney Norris.
Thank you, Your Honor. May it please the court. This case, obviously, you just said you know the facts, but the case basically was an alleged home invasion where my client is alleged to have gone in and threatened 3 people, and there was also a small child there. there was a gun later found underneath some couch cushions, and he was charged with home invasion, armed kidnapping, and related charges. The issue, which I think is the issue in this case is whether or not the Commonwealth overstepped its bounds in closing argument when suggesting that the defendant was threatening and intimidating, and the reason for the witnesses, specifically the main objection. The objection was made to Saad Atros, which was the male victim, the boyfriend of Ashley Dodge, who was my client's ex-girlfriend. But I would suggest that the standard of review in the case goes to the statements made by the prosecutor to both regarding Ms. Dodge and Mr. Atros, as well as the evidence and some of the questioning that was done during the case, the sympathy argument that was made, and the refusal of the trial judge to give a curative instruction under Commonwealth versus Rosa. And I think it's the Commonwealth tries to separate it in its brief, saying that the objection was only made to one witness, and it should only be the standard review should be prejudicial error for that witness, and for Ms. Dodge it should be the higher standard. I would disagree with that, because the specific curative instruction that was requested was because my client was being suggested my client was dangerous sitting in the courtroom, and that's why the witnesses were giving somewhat inconsistent testimony, refusing to answer questions until prodded, giving different versions of the event. And the prosecutor made the argument that it was because they were terrified, and specifically to Mr. Atros, that he was an abject terror if you listen to the 911 call. And it was based on the incident itself. So the objection was to the fact that my client was being characterized as a dangerous person sitting in the courtroom, and that's why the testimony was being given in the inconsistent way that it was. And I would suggest that is Rosa, and the objection was made to the argument that my client was being portrayed as a dangerous person. So the entire argument should be looked at, including the comments regarding Ms. Dodge, including the statements made and the questioning made during trial. So I do believe that the standard review should be prejudicial error for everything that I argue in my brief. That being said, the Commonwealth tries to make the argument again that arguing that fear of a defendant is proper argument. I would disagree with that. The Commonwealth cites Commonwealth versus Fitzgerald, a 1978 case, where there's one paragraph that makes the statement that suggesting fear as a reason for inconsistent testimony is not per se out of bounds. However, that case, again, a 1978 case, makes the point in its own footnote that they are speaking of generalized fear, not specific fear to a particular defendant, not witness tampering or intimidation, which is what occurred here. The Commonwealth is trying to suggest that my client was intimidating and tampering and preventing the witnesses from testifying. And I'll touch on that in a second. But even the Commonwealth's own case, Fitzgerald, makes the point that they're not speaking of this kind of generalized fear that is a proper argument for the Commonwealth. And if you go ahead 16 years to Commonwealth versus Carter, which I cite in my brief, Carter makes clear that arguing that fear of defendant without evidence.
But here, counsel, wasn't there, I mean, with regard to, I'm not quite sure how to pronounce that, Saad, it was a very particularized reluctance. It wasn't, in general, he couldn't say this or wouldn't do that. It was, he showed reluctance to admit that he was dating the victim. Wasn't there lots of evidence in the record to support the suggestion that he may have feared how the defendant would react to that acknowledgement?
Well, only if you believe that the allegations were true, which is the other problem. In order to believe in order for that fear to be rational, you have to believe that the allegations are true. And that's what Commonwealth versus Barrows says is out of bounds, which I cite in my brief. That's circular reasoning. In Commonwealth
but in Barrows, I mean, it was particularly noteworthy that the prosecutor said, who are you going to believe, some murderer or these other people? Here, this is a much narrower, more specific issue, isn't it?
Well, it might be a narrower issue, but I think it's the same problem. In order to believe that the fear is justified, you have to believe that my client's guilty. And that's the whole purpose of the trial. So in this case, in order to believe that my client, that the witness is justified in his fear of my client, you'd have to believe that my client actually went in there and made all these threats, making the questioning who his girlfriend's sleeping with, in order for that fear to be justified. And that's the circular reasoning that's addressed in Barrows. It's just kind of dressed up in a different fashion. And even in the case itself, what was being said in that apartment is not entirely clear, whether it had to do with childcare, whether it had to do with relationships. But I do believe it's Barrows all over it. And I'd just like to point out too that it's not just that one statement. This was the Commonwealth's theme, throughout the case. The Commonwealth at the beginning of the case wanted to address the witness's reluctance to come in, and it put it on the record, transcript at 5, that Dodge and the sister Salma might not be coming in and being forthcoming, and she suspected it was based on fear of the defendant. Suspected. Again, during trial, after a bench warrant was issued for Miss Dodge to come in, at transcript, I think it's 2 at 111, she asked the trial court to hold a voir dire of her own witness, her own victim, in order to investigate whether or not there was any witness intimidation going on or any tampering going on. And the judge rightly told her, no, you can investigate, you can talk to your own witness. If you have evidence of this, you can bring it forward, but we're not doing that. If you have no evidence, we're not doing it in a voir dire in the middle of trial. But the prosecutor suspected that was what was going on. And the prosecutor...
Counsel, it's not unusual in the domestic violence context to have witnesses who are reluctant. And this witness, from all accounts, was reluctant to come in and testify against the father of her 2 children.
I have no doubt.
Why wasn't it fair game for the Commonwealth to address that reluctance? And in so doing, the Commonwealth, the prosecutor, in fact, pointed out that there are many reasons why the victim may have been reluctant, and noted that potential fear was one of them. Why wasn't that, again, supported by the record? And
there was domestic violence victims clearly reluctant to come in a lot. In a lot of cases get dismissed, especially in the district court level, as your honors know, when witnesses are reluctant to come in. And the Commonwealth was right. There are a lot of reasons for that. Sometimes they're afraid. A lot of the times they just don't want to go forward because they're back together with the defendant. The family issues, money issues, there's a million reasons. But to come in and suggest in a case like this, alleged violent felony, that the reason why not only the victim, but the victim's boyfriend and the victim's boyfriend's sister are giving inconsistent testimony is because they're afraid of the defendant as he's sitting in the courtroom is out of bounds. And I think Carter is directly on point with that. You need some proof.
So I'd like to just add a couple of facts into Judge Milkey's question to deal with the witnesses and the broader scope of the trial, not just domestic violence. The witnesses, this is a gun case in large part. The allegation is he came in with a firearm. And so, it's not, common sense tells us, I think we've all heard, snitches get stitches or what have you, for witnesses to be reluctant to come in sometimes not victims at all, just strictly witnesses, to be reluctant to come in and testify against a shooter or somebody with a gun. And that's just kind of common, I don't want to say a common sense understanding of human nature. So on this case, when the prosecutor points to, you had the opportunity to see him, you had an opportunity to hear his questions. You could listen to the tone of the 911 case. Why is that not all fair play?
Well, it's interesting that you used common sense, as a word, because that is exactly what was said in Carter. The prosecutor said, use your common sense, and the court said common sense means afraid of the defendant, and that was improper in Carter. I think there's a difference between judges and prosecutors and defense attorneys knowing what happens in the majority of cases and it being told to a jury in a specific case. I think that's where the problem lies. We as former trial attorneys and trial judges and who've seen this stuff on a day in and day out basis kind of have our own, I would suggest, our own prejudices when it comes to this stuff, because we know what happens a lot of the times, but it's not always. And I think that's the problem here, is you need to put together evidence that is proper for a jury. And in a case like this, without some evidence other than a prosecutor's suspicion that what's going on here is the witnesses are reluctant, because the witnesses wouldn't even tell the prosecutor something happened. That's why she needed to voir dire them, because they wouldn't talk to her and tell her. So there was no evidence other than the incident itself to suggest that they would be afraid of the defendant. And I think Carter and Barros, when you read them together, say you can't do that. You need evidence of some sort of witness intimidation to make that argument. And it can't be, under Barros, a circular bootstrap. You can't say, because of what we want you to convict him for here, you can infer that they're afraid. There needs to be some extra evidence, and there just wasn't in this case. And if I can get back, I'm sorry, I went a little dry there. I apologize.
No, but getting back to Judge Desmond's question, here you had a contemporaneous record, in a sense, the 911 call, in which we don't have the call, so we don't know what he sounds like, but apparently he was petrified on the call. Could the jury take into account the fact that he was petrified on the call? And if so, what is wrong with the prosecutor calling attention to his fear?
I think under Carter and under Barros and in the other cases, there needs to be some proof that the person who is testifying is afraid of the defendant other than the incident itself, or other than the 911 call, or else you open up a Pandora's box. I would suggest every time a 911 call is made, then you can make the argument that the person is, whatever, there's a credibility issue, as in this case, that the person is just afraid that they're going to be attacked by the defendant, which is what the Commonwealth was suggesting. In the Commonwealth's own questioning, where she was asking her own witnesses where the other witnesses were, she's suggesting that they're not coming in because they're afraid of the defendant, to the jury. And that is not something, even though the objections were sustained, that's not something that the jury missed out on. And then she hammered it home in the closing argument. So I think if the Commonwealth wants to go down that road, there needs to be evidence. And there wasn't in this case, other than the incident itself.
Well, the specific objection you're making, as I understand it in your brief, as to Saad, was his reluctance to admit he was currently dating the victim.
Yeah,
and in that portion of the prosecutor's closing, where he says, why do you think he wouldn't tell me initially when I was asking him? Could it have been that he was fearful of the anger from the defendant? Because when the defendant came in, he theoretically was saying, who were you sleeping with, or whatever. That would have made the logical inference is Saad heard the defendant being upset about her possibly dating somebody at the time of the incident. He doesn't want to admit it now in front of him at trial. I mean, that's the one thing that was brought up in your brief as to him. As to her, it was limited to, she kind of looked like she didn't want to be there. And why do you think she doesn't want to, why do you think she acted that way? So am I correct? It's those two references that are under appeal?
It's those two references. I would suggest that that was the tip of the iceberg for the defense attorney making the objection, that he objected to Saad. But Saad was just one part of the prosecutor's whole scheme. I think you have to read it, as Rosa says, in totality, where he made the statement about Saad, made the statement about the 911, made the statements about Ashley Dodge, the questioning of asking Saad himself, where's your sister? And there's an objection. And then, because it's wildly inappropriate, where are your own witnesses, suggesting that they're not there because they're afraid, and then have the objection sustained, and then asking, where's Ashley Dodge? Objection sustained again. And then spending all the time in the closing argument, arguing the credibility, problems, which is the center of the entire defense. It was all credibility argument, was due to their fear of the defendant. I think you have to read it together as a whole, including the sympathy argument, which I put in there because I believe that was an improper statement in closing. It was unobjected to, but I think you have to read it together with the rest of the Commonwealth's argument, and the fact that this was clearly the Commonwealth's prosecution strategy, in that they brought up the fact that the witnesses weren't there, were reluctant to come, wanted to voir dire their own witnesses, asked these questions they knew were inappropriate to just get out the question, not the answer, and then made these improper closing arguments. So I think,
Counsel, your time is up. I think we have to get us to a close unless my colleagues have further questions.
I have one other question, kindly. Doesn't the prosecutor say, in dealing with the reluctance of Ms. Dodge, and of course it's more complicated than that too, right? She's been dating the defendant since high school. They had broken up pretty recently. They have 2 children together. There are lots of reasons why she might not have wanted to be here and might not have wanted to talk about what happened to her. Doesn't the prosecutor make that clear?
yes, that's true, Your Honor. She does say that. I did cite that in my brief as well, and I do, commend the prosecutor for adding that, but I don't think it fixes the problem.
Okay, thank you very much. We'll hear from the Commonwealth.
Good morning, Your Honors. Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. There's no general prohibition against discussing a witness's demeanor, including a witness's fear, so long as it's based on the evidence. And in this case, all the prosecutor's inferences were well supported by the record. And all those record citations are in my brief. The problems in Carter and Barrows, which my brother relies on, was that the inference in those cases found no record support. Here, Saad's reluctance to testify about being Miss Dodge's boyfriend was supported by the fact that this whole incident seemed to stem from the defendant's belief that Miss Dodge was dating someone else, and in response to that, he threatened her with a handgun. So I think it was a reasonable inference for him.
But what do you do about the circularity?
I don't think that's a real problem. I mean, the prosecutor is an advocate for one side, so they're going to be asking them to believe every part of the testimony. So you could say everything is circular. To find that if the prosecutor asking the defendant to be found guilty would be circular, because then you'd have to believe everything, all the evidence. So I don't really think that's a real issue. The prosecutor is allowed to argue the fair inferences that come off the record. So here, there was a specific problem where Saad refused to answer a question. That's a problem for the prosecutor, and the prosecutor is allowed to argue to the jury based on the evidence, and there's plenty of evidence to this point, a reason why he might be reluctant other than untruthfulness. As to Ms. Dodge, the prosecutor, I mean, it's hard for us to tell because it's a cold record, but she was commenting about her demeanor and saying there's a reason that she might seem a little hesitant to testify. She was reliving a petrifying event, Ms. Dodge's own word, and I think that's a fair argument to make. There was nothing particularly.
Okay, can I just ask you about Carter? Because
Sure.
You're correct that our court said there was no evidence there. But what it specifically said was there was no evidence of witness intimidation. which is different from fear of the defendant more generally. Can't you read Carter as saying that if you're going to say that something about the witness testimony has to be viewed through the lens of fear of the defendant, then it can't just be based on generalized fear of the defendant. It needs to be based on incidents of witness intimidation.
I don't think necessarily has to be witness intimidation, but here it was very specific as to Saad. The argument was he was hesitant to answer one question, and that question was, "Are you dating Miss Dodge currently?" And the prosecutor drew a fair inference based on the record that he was afraid specifically to answer that one question because the defendant acted violently when he believed that Miss Dodge was dating another person. So this wasn't something that was totally outside the record like it was in Carter. There was no evidence of witness intimidation in Carter. Here, there was evidence that the defendant acted violently when he believed Miss Dodge was dating someone else, and it was a fair argument for the prosecutor to suggest another reason for his lack of candidness in that one question, other than being a untruthful person.
Do you agree that prejudicial errors is the standard of review?
For Mr. Saad, not for the comments on Miss Dodge, there's no objection, no chance for the trial judge to correct any alleged error. And frankly, I don't think the standard review particularly matters because I don't think there's any error to begin with. So I don't think you ever get to whether it's prejudicial or a substantial risk. And I would just point out, I know my brother pointed out that Fitzgerald is an older case. If the court wants to look at a newer case, that also stands for a proposition that fear is a witness fear and reluctance to testify is a proper avenue to explore. I think you can look to last week's decision in Commonwealth versus Gibson, SJC 12159 from January 27th. It reaffirms that proposition. So Fitzgerald is not, it's an older case, but it's still good law. And if there are any other questions, I'd be happy to take them. And if not, I'd rest on my brief.
Seeing none from my colleagues.
Okay, we are live and recording.
Thank you very much. We are back on the record with our fourth case of the day. INTERNICOLA versus Massachusetts State Police, 2021 P 428. I would remind the parties that we have read the brief, so we are familiar with the facts and the arguments. I say that because I would urge both sides, to the extent possible, to cut to the chase. And with that, I will turn the floor over to Attorney Giannoulis.
Thank you, Justice. Kerry Giannoulis for the plaintiff appellant Nicholas INTERNICOLA. May it please the court. As the panel is aware, there was a voluminous or quite large record appendix, and a lot of different documents relative to the investigation or investigations of Trooper INTERNICOLA. I merely say that because, as the court knows, this was a single count retaliation case brought under 151B. Pro se. I appeared later on the case. I think the real issue on appeal is vis-a-vis Justice Judge Liu's dismissal of the trooper's single count is, as in any summary judgment case, finally, is it whether a reasonable juror looking at the facts, the disputed facts, and if these disputed facts exist, whether they come to one conclusion or another, or should the case end on the pleadings, meaning the summary judgment filings. In this case, there are two basic issues. We believe, plaintiff believes, that there are enough disputed facts that a reasonable juror could find that Trooper INTERNICOLA on September 5th, 2013, the key incident in this case, informed Lieutenant Hines that an incident had occurred, and the court is well aware of it, but that he still wanted protection from Timothy Gillespie, the other trooper, who previously had made derogatory terms or uttered derogatory comments on 2 occasions, which I don't know if the state police, they dispute it, but there's no finding either way if that actually occurred. However, on September 5th, this same harasser engaged Mr. INTERNICOLA in the garage, mumbled something, and then events transpired.
So we don't know what he mumbled, right?
No, we don't know what he mumbled. And I think it goes a good way to the credibility. I know it's a summary judgment case, Justice Desmond, but it goes a good way to the credibility that Mr. Trooper INTERNICOLA, you know, easily could have said, and he didn't, that the derogatory term was used again, because you used twice in the past. And that is Trooper INTERNICOLA's allegations. Never said that. Said he was mumbled something. Trooper INTERNICOLA, and I don't want to get too much in the facts, I have limited time, approached, said his term, said something, which he meant an IA investigation was coming down. But
let me interrupt you. I know you have limited time. Your client seems to put, I'm gonna say, a more favorable spin on what he was suggesting when he responded to the trooper's mumbling under his breath, that, you know, you're going to get what's coming to you, or whatever the case may be. It was free for the judge not to. First of all, the trooper who that was said to immediately went and reported it, correct?
He went, I think there's a dispute there. He went in because it was the start of the shift to see Lieutenant Hines, who was the shift commander, and there was a discussion concerning it. Gillespie was never interviewed concerning the September 5th incident, or at least on the 5th, because Major Christiansen testified to that. So I don't know if Trooper Gillespie ran in there out of fear to say something happened, or just said, oh, by the way, this guy who has been making allegations against me for years approached me again and said something. So
and threatened
him, which in the earlier incidents, which are investigating the IA reports too earlier, Gillespie never said that he ever felt, well, the first incident he did supposedly was an altercation, but the second incident in March of 13, he said he didn't feel threatened by Trooper INTERNICOLA. So yes, parties, there are going to be spins. It's litigation. And I don't mean spin in a derogatory term. I mean, we put cases on. But when INTERNICOLA goes in to talk to Lieutenant Hines, he's taken back a little, because to him, this guy has been picking on him for 2 years. And some of that picking is based on a protected, or at least a allegation of harassment, which would be protected conduct, because the trooper believes that he was insulting his national origin.
And let me ask you just one little quick question on that point. At the time that happened, he didn't report it right away.
At the original incident, he didn't report right away.
When he was
did not,
to
but
as the N-word, and his family as the N-word, because he's Syrian background or whatever. He didn't report that right away.
True, Justice Desmond, happened March of 2012, didn't report it to 13, but in the record appendix and in the IA investigation, which came out mid 2013 or late 2013, they interviewed many troopers who knew in that 8-month period before Nicholas came forward that this had happened. I mean, there's a whole, in the IA report, there's at least 20 paragraphs about troopers, friends of Nicholas, friends of Timmy Gillespie knowing about this. INTERNICOLA testified in that IA investigation, and he thought he could just survive it. He could just work there. I mean, you know, part of our damage are also Troop F is a very lucrative place to be. The court would know that from the Yee case. He didn't want to stir the pot too much. It doesn't mean he wasn't offended by what was said. I don't know if it rises to the level of a hostile environment, but for retaliation, all you need is a reasonable belief that there's been some kind of harassment. So getting back to the September 5th, he gets in there, he tells Nick arrives in, tells Hines what happens, tells the whole story. Also tells Hines that, he has been getting picked on this whole time, including today. You're glad at me. This is what's important in this case, and it goes to why it should go to a jury. The state police, since 5th, 2013, have said that, they investigated the early incidents, but the incident on the 5th was just this one-sided incident where this aggressor, this armed trooper, scared them so much that we had to do something. Okay. Now, if you look at Lieutenant Hines' workplace violence report, I believe it was 2 days after, he in that report mentions that Nick INTERNICOLA is discussing and talking about getting picked on up to the present. There's an IA investigation a week later. In that recorded statement, Hines says the same thing. He's actually asked by the investigating trooper, what about a hostile environment, meaning with Nick? And he said, well, he's been complaining about that. Okay. So
does that make it retaliation, the fact that there was some ongoing bad feelings of bad blood, so to speak, between co-workers that are, just because one gets transferred, it is now retaliation?
Well,
can't that be factored in? Can't that be factored in?
It can't be factored in, but it also gets to the later argument in the second step of the Mull analysis. But Judge Liu, a great judge, but in the prima facie argument, he's saying, which is the law, you need the protected conduct, you need the adverse action. The only protected conduct I can see is months before it's to attenuate. And I'll agree, there's many cases to attenuate it. Our theory, in which we want a jury to hear, is that there was a protected conduct again that day, just to satisfy the prima facie case, which I know isn't a jury issue, but so we can get to if the legitimate non-retaliatory reason was pretextual. Yes, they can weigh the fact that there had been some bad blood, but it's what they did about that bad blood. And it gets into the second step of the Mull analysis. What they did was either incredibly, and I know we're getting to the Sullivan case here, but incredibly minor thing to do if you're terrified of a trooper who Hines himself said, I was worried about a man who had a gun and ammo. Christian said he was worried about violence. Okay. So it gets into, and we're getting into the second step of the analysis, but it gets into, you're that worried about a trooper, okay, that all you're going to do is move him, and it's in the record, Troop A, 5 miles away. You're not going to go through all the other, and we've listed in our brief, other protocols you could have done according to the ADMs. You're just going to do that. Or, and this gets to getting to a jury, or as we put in, I see I'm running out of time, or as we put in our brief and the facts relay, that Hines in those same two, a recorded statement, workplace violence report, never says that he's afraid of Nick INTERNICOLA, never says he was yelling and screaming out of control, and that's in our brief. In the interrogatories, 6 years after the event, Hines says he was yelling, screaming out of control. He was physically scared of him in his office that day. Christiansen says that he was so scared of violence, okay? Nothing about that back then. A jury could infer, okay, if we can get through the prima facie case, if there was protected conduct that day. There could have been another reason, but just the prima facie case, which is not supposed to be a high burden, get to the, was this legitimate non-retaliatory reason pretextual because of inconsistencies? They're saying now he's yelling and screaming. No one's saying he's yelling and screaming back then. They're saying we had to move him because their words, threat of violence. They moved a trooper, an armed trooper, for threat of violence 5 miles away. They didn't send an anger management. They didn't remove his sidearm. They could have. They didn't do numerous things we listed. Okay. Or is it that this incident wasn't as big as they said? They were tired, and the jury could infer this. They were tired of a complainer. And one of the things he was complaining about was incidents of a harasser making racial comments or national origin based comments. And he wasn't relenting on it. So let's get rid of this complainer. Let's move him away from where he is to get rid of him. So it goes to their inconsistency. We cited the case, the First Circuit is Title VII, that inconsistency is one of the ways you attack pretext. Also, the Yee case has that classic line where, yes, under Sullivan and Mole, the legitimate reason can be absurd, but that just satisfies that step. The more absurd it is, the more easy it is to attack. And I hate to jump into the next part. I see my time is running. What we're saying here, I think, in both the issue of prima facie and the legitimate and non-retaliatory reason for moving Mr. INTERNICOLA, is there's enough disputed facts that a jury should be able to take a look at this and to say, this could have happened. This could have happened, not could, there's no factual basis for it. I mean, there's numerous inconsistencies in Hines' testimony. There's getting back to, did Christensen know of what about my protection prior to calling downtown? And there's factual inconsistencies. We know Hines did. He admits to it in statements right after it, so he knows. Hines says he went right up to Christensen to tell him what happened. Doesn't remember what he told him. He remembers the part, he said, your day is coming.
And that's not disputed, is it?
No, that's not disputed. Trooper INTERNICOLA said your day is coming because the IA report was coming down. The actual first IA report came down in August. This happened in September. I'm sure it wasn't distributed to either Gillespie or Nick by that time. So there's factual inconsistencies on what Christensen knew. Christensen didn't know. He said, I don't remember exactly what I was told. So a jury could infer you also were told that this guy is saying, we know an incident happened, but this guy is saying, he's picking on me again. He's instigating again. I'm making a new complaint, and we cited cases of what constitutes a complaint. Okay. Also, there's the incident of what Nick did. But if you look at it in that frame for a jury, because there's enough disputed facts, you got protected conduct, you got an adverse action to transfer, and you got to happen on the same day.
Counsel, I have a threshold question. Is there any potential issue of waiver here? And by that, I don't mean the claim preclusion issue. I mean, as I understand it, your client signed off on the transfer from Troop F. Were these claims reserved either as a matter of fact or as a matter of law?
Well, I think, Justice Milkey, first, that was a year after, involved two other incidents he wasn't transferred on September 5th for. I don't believe under law that would be, common law waiver, I understand. I don't believe when he moved, there's any document that says I waive, like a separation agreement, I waive the right to bring any kind of claim, cause of action. Did he waive, what I've seen is he was moved. So if there's findings of fact that, that I understand the court's question, common law waiver, a known relinquishment of a known right. I don't know. I don't think there's a case on point which would say a year after, in this fact pattern, a year after someone was moved, a layman too. Now, he did have an attorney. There was a union attorney a year later, but would that be a waiver of his 151 retaliation claim from a year prior? Could it limit damages? I don't know. It's an excellent question. I do know, I don't know of any case where, because it would be very novel too, just in any kind of employment discrimination, right? That somebody a year after some event would sign kind of separation agreement or waive their rights. It would be a novel kind of thing. It wouldn't happen that way.
Okay, do either of my colleagues have any questions?
He was moved, but he got to pick where he was moved to, right?
Yes, Justice Desmond. He was moved where and this would go to a damages argument.
I get it, from the airport.
Oh, yes, he was moved where, actually, he first wanted to go to the motorcycle division back at headquarters because there's more opportunity to make money, and he couldn't. So they moved him to A, which is Revere in Danvers. F is Logan.
Thank you.
Thank you very much, counsel. We will hear from the state police.
Good morning, Allison Burton, Special Assistant Attorney General on behalf of the state police. The key to understanding this case is a chronology. In January and March 2013, Mr. INTERNICOLA complained about alleged racial slurs. In response, the state police opened an internal affairs investigation. No adverse action was taken. 6 months later, in September 2013, Mr. INTERNICOLA threatened another trooper, admitted he made that threat, and was transferred hours later.
Can we pause there? When you say he admitted he made the threat, he admitted he said a particular phrase. And,
yes.
And there are different interpretations of that phrase. On summary judgment, don't we have to accept his interpretation of that phrase, number one, and then number two, given that his defense to the threat was that, oh, I was referring to the IAB investigation, couldn't a jury have reasonably inferred that the subject came up again during this era of your timeline?
So with respect to your first question, I think that the thing to look for summary judgment in a retaliation case is really goes to the reason for the transfer, the department's reason for the transfer. So it's how did the department understand that phrase? And the department, Lieutenant Hines and Major Christiansen, clearly understood that as a threat of violence. And then for your second question, since it referred to the IA investigation, whether that was renewing the complaint, a couple of things on that. First, when Trooper INTERNICOLA made the statement to Trooper Gillespie, he didn't say your day is coming very soon because of this internal affairs investigation. He just said your day is coming very soon. And then later he added that explanation. So on the initial front, he didn't say that. And he confirmed to Lieutenant Hines that he didn't clarify to Trooper Gillespie that it was about the internal affairs investigation. And then as to whether that is renewing these previous complaints about racial slurs, there are numerous places in the record where Mr. INTERNICOLA addresses the statement he made to Trooper Gillespie, and he addresses a conversation he had with Lieutenant Hines about that conversation almost directly after it happened. And in all the places where Mr. INTERNICOLA describes his conversation with Lieutenant Hines, he never once re-raises any complaints about racial slurs. So for example, at volume 1, pages 33 through 34, Trooper INTERNICOLA describes the conversation with Lieutenant Hines in detail, and he admits that he made the statement to Gillespie. He says that he raised some sort of issue about a cruiser smelling like alcohol, but he never claims that he re-raised any complaint about racial slurs with Lieutenant Hines after that incident occurred. And the same is true for other places in the record where Mr. INTERNICOLA describes that incident. For example, volume 1, page 14, which is his amended complaint, and volume 2, page 5. which is his EEOC statement. So these statements from Mr. INTERNICOLA describing the conversation with Lieutenant Hines are undisputed. And in those statements, he doesn't make any claim that he was renewing a complaint about a racial incident. So because of this sequence of events where the initial threats occur, or excuse me, the initial complaints occurred in January and March 2013, nothing happened for 6 months. In September 2013, he admitted to making the statement to Trooper Gillespie and then was transferred hours later. The timeline shows that there was no retaliation. Instead, Mr. INTERNICOLA was transferred directly after and because of the statement he made to Trooper Gillespie. And that
so your counsel, just to put this in context, you're saying we don't even get past the first prong of the McDonnell-Douglas test.
Yes, Your Honor, that's exactly right. We think there are two independent reasons to affirm the summary judgment decision. And the first is Mr. INTERNICOLA can't even make out a prima facie case of retaliation because he can't establish causation in view of this timeline. And the second reason is that
before we leave the first point, Judge felt 6 months was too long. You obviously feel 6 months is too long. What is not too long?
That's a great question.
Why couldn't a jury conclude that, well, maybe it's less likely if it's 6 months, but it's still possible. 3 months, 2 months?
So I think that the Mole case addresses this, and the court there actually says that they're not going to address the absolute shortest amount of time that would be sufficient, although the court does cite a case saying that a gap of 4 months is insufficient to establish causality. But the more important thing, I think, in this case is that Mr. INTERNICOLA doesn't even argue that a gap of 6 months is sufficient. So on page 27 of the blue brief, he says that a gap of 6 to 8 months, like the one we have here, is alone not enough to establish causation based on the timeline. So the first point, as we've discussed, is there's no prima facie case because of this gap in the timeline and because Mr. INTERNICOLA himself never claims anywhere in the record that he re-raised any racial complaint on September 5th. And the other thing that I'd like to discuss on that front is that it's also undisputed that Major Christiansen had to get approval from headquarters to transfer Mr. INTERNICOLA before transferring him. And that's undisputed because we make that point on page 21 of our red brief. And Mr. INTERNICOLA had the opportunity to respond to that in the reply brief and chose not to do so. And another thing that's undisputed is that at the meeting that occurred between Major Christiansen and Mr. INTERNICOLA on September 5th, Mr. INTERNICOLA was informed at that meeting that he was being transferred. So that means the transfer decision had already been made. And that is on pages 20 through 21 of the blue brief, as well as 21 through 22 of the red brief. So given the sequence that Major Christiansen had to get approval before transferring Mr. INTERNICOLA, and that at the meeting that occurred between Major Christiansen and Mr. INTERNICOLA on September 5th, Mr. INTERNICOLA was informed that he was being transferred, that means that Major Christiansen and his superiors made the decision to transfer Mr. INTERNICOLA before Mr. INTERNICOLA ever re-raised any complaints to Major Christiansen on September 5th. And then one more point on the prima facie case. I think the other really important issue here is that even if we assume that Mr. INTERNICOLA had renewed his complaints on September 5th, and the record, including Mr. INTERNICOLA's own statements, don't support that, the larger picture undercuts any inference of causation based on the timeline. And a case that supports that is Pont v. Still case. There, the court found that even when chronology could potentially point to causation, if the bigger picture undercuts that, it doesn't suffice. Lieutenant Hines and Major Christiansen knew about Mr. INTERNICOLA's repeated complaints for 6 months. Nothing happened, no adverse action. The only thing that changed on September 5th was Mr. INTERNICOLA made that statement to Trooper Gillespie, "Your day is coming soon." And that's when he was transferred, right after that issue occurred. So that also undercuts any finding of causality in this case. So first independent ground for affirming the larger picture in the facts and the record in this case showed that there's no causality and Mr. INTERNICOLA can't make out a prima facie case of retaliation. But the second independent ground for affirming the summary judgment decision is that the department had a legitimate non-retaliatory reason for transferring Mr. INTERNICOLA in this case, and that is his statement that Lieutenant Hines and Major Christiansen interpreted as a threat to another trooper, Trooper Gillespie. And there's no dispute that Mr. INTERNICOLA made that statement, that he confirmed to Lieutenant Hines that he made the statement, that Lieutenant Hines told Major Christiansen that Mr. INTERNICOLA made the statement, and then Mr. INTERNICOLA was transferred. Now, Mr. INTERNICOLA tries to sort of fight this legitimate reason for the transfer by saying that it's implausible that the state police didn't do more to de-escalate the threat of violence from Mr. Nicola. But as the Superior Court found, this strained argument is unpersuasive. As an initial matter, that the state police erred in favor of protecting Mr. INTERNICOLA's career instead of terminating him is not evidence of retaliation. If anything, it shows the opposite. As another matter, by saying that the state police should have done more to de-escalate Mr. INTERNICOLA's violence, Mr. INTERNICOLA is asking this court to evaluate whether the state police took the right steps in response to potential workplace violence. But that is directly prohibited by Mesnick v. General Electric and Sullivan v. Liberty Mutual. Both of those cases state that courts cannot sit as super personnel departments assessing the merits or even the rationality of an employer's non-discriminatory business decision.
But don't the cases, at least some other cases, also say that, you know, inconsistencies and irrationalities is one way of demonstrating pretext? It's irrelevant on its own terms, but it's an indication that something else may be going on here.
Yes, Your Honor, the cases do say that inconsistencies and irrationalities can support pretext, but cases also say, for example, going back to Mesnick v. General Electric, that at summary judgment, genuine issues of material facts aren't based on dreams. There have to be, you know, real disputes here, not sort of conjecture or speculation. For example, one of the supposed issues of material fact that Mr. INTERNICOLA points to is Lieutenant Hines' description of Mr. INTERNICOLA on September 5th and whether Mr. INTERNICOLA was actually heated. But Lieutenant Hines' description of that is consistent, starting with the Internal Affairs Investigation transcript interview, which took place just days after this conversation with Mr. INTERNICOLA. And that's at volume 2, pages 118 through 120. And in that, Lieutenant Hines says that Mr. INTERNICOLA was, you know, ranting, he was out of control, he was venting, he needed to calm down. So because, you know, these alleged inconsistencies are really belied by the record in this case, that's not enough to overcome the evidence of a legitimate non-retaliatory reason to transfer Mr. INTERNICOLA.
I want to ask you, I know you, to your colleague's surprise, have disavowed making a claim preclusion argument, but I want to ask you about that anyway. Why not? I mean, it's the federal court ruling was, based on the merits, that the complaint as pled did not state a claim. And it was dismissed for that reason. Why isn't that enough to establish claim preclusion?
Your Honor, we've decided not to press the claim preclusion issue in this appeal because it presents a tricky issue of 11th Amendment law regarding whether a 151B claim can be pursued in federal district court. So because there are two independently sufficient reasons to affirm the decision, we thought it was unnecessary for this court to address that issue.
Okay, now I understand.
But, I guess the last thing I would say is the timing is really key here. Nothing happened for 6 months, and then Mr. INTERNICOLA was transferred hours after this statement, which was interpreted as a threat. So the summary judgment ruling should be affirmed.
Okay. Do either of my colleagues have any further questions?
If I may.
No, counsel.
thank you.
Counsel, there's no opportunity for rebuttal.
Oh, I'm sorry. Sorry.
Hearing no further questions, time has expired. The case.
Okay, we are live and recording.
Thank you very much. We are back on the record in 2021 P673. The case is CK versus ZK. I would remind the parties that the case is partially impounded, and please no references to names. I, for one, would find it more helpful if you would not refer to the initials, but refer either to plaintiff and defendant, or for that matter, husband and wife, understanding that the parties are no longer married. I would also like to remind the parties that we have read the brief, so we're familiar both with the facts and the arguments. And I say that in order to implore you, to the extent possible, to cut to the chase in your arguments, given that 15 minutes generally is not a great deal of time. And with that, I will turn the floor over to Mr. Curhan.
Thank you, Your Honor. May it please the court, Dana Curhan representing the husband in this case. We challenged the permanent extension of the 209A abuse prevention order. As this court is, I'm sure, well aware, there tend to be two situations where these orders are issued. The first is where you have somebody who's somebody who regularly engages in domestic violence, and probably somebody pretty close to some of my criminal clients. The second is when a couple is in the process of a divorce, and you have a contentious divorce. And we don't contest the initial issuance of the order or the first couple of extensions, but I think the party's divorce is now final, and there's really no need for a permanent order. I mean, the party's divorce decree does two things. First, the husband made a lump sum settlement with the wife, and so there's no need for any further contact between the parties. But the second thing it did is there's actually a permanent no contact order. And I would suggest that that is more than sufficient to allay any concerns about any further repetition of the behavior that she reported. Again, we don't necessarily agree that the behavior took place or that it was as described. There was which the wife described as a biting incident in January 2019. And then there were some other incidents, some discussions of how to kill your wife, that there's a dispute as to whether they were discussing a TV show or whether the husband was just making some threats. That was in May. And then at the end of June, she went and got this order. it's
So,
been,
Attorney Shanahan, just to interrupt you for 1 second, you indicated that the divorce decree has a no contact order, is that correct?
it does.
And what's the consequence if they violated the no contact order of a divorce decree?
There'd probably be a contempt. Obviously, if there's something that puts her in danger, she can call the police. But I think the remedy for that is a contempt.
And so if they had a permanent order on restraining order, which the consequences of a criminal action, then why not go back to the family court and vacate the no contact of the divorce decree?
I think probably the no contact order is more appropriate. It tells them just stay away from each other. Divorce is over, stay away from each other. And that's really what's needed here. The problem.
And that court, a different judge, saw fit to impose that condition, correct?
Yeah, and I don't think either party objected to it. I think they both, there were reported incidents on both sides. And, obviously they weren't getting along, and obviously, that was something that it was part of the decree. So I don't have any problem with that, by the way.
But a 209A order has a lot more bite, doesn't it? Because violating it is instantly a crime, number one, and number two, there are important collateral consequences in terms of gun ownership and such. I don't want to put words in his mouth, but I think my colleague's question may be along the lines of why doesn't the existence of that no contact order actually cut the other way? That a separate judge has independently determined that these parties should have nothing to do with each other.
Well, I mean, I don't think that cuts both ways. I think that cuts in my client's favor. They weren't getting along. And the judge said, stay away from each other. And I think that's enough. That's all that's needed. There's no allegation that my client has guns or has ever had guns. I think he would have a very difficult time getting a gun permit, given the fact that there were 209A orders issued in the first place. But the real consequence is that my client travels all over the world. So instead of breezing through customs with his global entry card, he now gets pulled aside and questioned every time he travels several times a month. That's both domestic and international, and it's really problematic for him.
But this isn't about the consequences of your client. This is about the appropriate action of the district court judge in issuing this permanent order. So you raised two issues in your brief. One is that it was not requested as a permanent order, only as a 1 year order. And I haven't been able to find where her request was for 1 year. Could you direct me to that, please?
I think, let me clarify that. In February 2020, there was a request for a permanent order, and the judge then issued a 1 year order. In February 2021, I don't think that there was a discussion about what was being requested. So maybe I'm wrong here, but I'm not sure.
Well, I'm just reading from your brief. You said the complainant had asked for a 1 year extension. And you made an issue out of that in your brief that if she only asked for 1 year, you shouldn't have given a permanent. And I couldn't find where she asked for 1 year.
I thought that was the case. I could be wrong, but I'm not sure. I know that.
So you can't refer to me anywhere in the record where she requested 1 year?
I don't think I can. But I also can't point to where in February 2020 she asked for it to be permanent.
But to be clear, you do not appear to be making what I might call a surprise argument, namely, had counsel known at the time that the order may have been permanent, he or she would have done something differently in preparing the case?
Probably not, because I think at that point, when the divorce was final and there are no further incidents in there. And he's essentially spends a couple of days a month in Massachusetts. I don't think there's any basis for extending it any further. And I think so. I think the answer to your question is no, it probably wouldn't have been handled any differently.
And counsel, as you, I'm sure, are aware, the fact that the order is permanent does not mean that your client can't go back and ask for the order to be vacated. What is your view on the difference in context and what that would mean from your client? Presumably he would have the burden of proof at that point, but beyond that, how different is that issue than an appeal of the initial order making it permanent?
I haven't seen I've handled a lot of these cases. I haven't seen very many, if any of them, that were actually vacated somewhere down the road. I've had cases where somebody said, look, the divorce was over 20 years ago, and I still have all these consequences from this restraining order from my ex-wife, who I don't even know where she is. Now, again, that legally, what does that mean? I mean, I'm not sure. But to say that, you have a remedy, you can always go back and have it, have the permanent order vacated. I guess my answer is easier said than done, and nothing that's going to happen in the short term. It'll be a year this month that it was extended, and I wouldn't see that being vacated in the foreseeable future. Now, when you look at the order, I think this falls into the category of people didn't get along during the divorce. Obviously, getting a 209A is a tactical advantage when you're going through divorce proceedings, and a lot of people do that. And my suggestion is that that's what happened here. When you look at it, you don't see the allegations of physical violence, other than the fact that 6 months before she said, well, he bit me, without a lot of context. And, once they're divorced, I don't think it should have been extended at all, let alone permanently.
What we do see, however, following the bite, is that he attempted to board a plane that she was getting on. And he said it was just by chance he happened to be getting on the same plane. And then he went to her dog sitter's house to engage in some further action. All that was before the court and free for them to consider, correct?
It was. When you look at the February 2020 hearing, the judge said, I'm not giving any weight to that allegation, and I'm not giving any weight to the claim about he went and tried to take her dog. So, I think, and that wasn't really, the judge didn't appear to credit that at the 2021 hearing was very brief. The judge didn't appear to credit that. It's an accident. They have a house in South Carolina, and they both bought a ticket to go down there, unbeknownst to the other. And she said, I never saw him there. I didn't see him. He left. But, and then she said, well, the state police made him leave. I don't think there's any real evidence of that. But the judge said, I'm not crediting that.
But the judge appeared to give full credit to the wife's concerns of the abuse that resulted in the underlying order. In other words, the biting, the discussion of killing her, the sexual assault, I think, was also part of that. And the judge, I think the judge used the word horrific. The case law says once that kind of abuse has occurred, because there was injury, there was a rape, there was biting, there was a threat of death, that lasting effect is grounds to allow an extension of an order. So what is your argument as to the insufficiency?
Well, my argument is that the judge seemed to focus on he said, I see a dozen of these a day. I read a dozen of these a day. And then he talked about, the psychological damage or whatever. But that's not really what the inquiry should be. The inquiry should be whether she is still in danger of imminent physical harm. And
well, I think the case law kind of differentiates a little bit where there's already been harm, which would be the occurrence here. That where the harm has already occurred, the lasting effect may be grounds for the issuance of the order.
I think it is not necessarily the psychological effect and whether she's traumatized. I think you have to take, and I think the case law supports this, you have to take an objective view and determine whether she is still in danger of imminent physical harm. And I don't think the judge made that inquiry. I think the judge said, I see these things all the time. Here's another guy who did this sort of thing. And my concern is that the judge is saying, I'm going to punish him for the psychological effect of what he did. Not necessarily that she's actually still in danger, but also, this sort of societal cost and damage caused by this sort of behavior, and the ongoing problem of domestic abuse, rather than whether in this particular case there's a danger of imminent physical harm. So that's really my point. I mean, I think once this divorce became final and once everything settled down, I don't think there was any further need for this order, and that is my contention.
Can you remind me if it was the same judge who denied the request for permanent order and extended it a year as to the judge who made it a permanent order?
I believe it was the first judge who issued the ex parte order, made it permanent. A different judge did the extensions. Unless there are any further questions, I'll leave the remaining points to the briefs.
And you agree that prior to it becoming permanent, it had already been extended a few times?
It had been, yeah. By agreement the first couple of times. And then it was contested in 2020 and 2021.
Okay, thank you very much, counsel.
Thank you.
We will hear from Attorney Bodanza.
Well, good morning, Your Honors. I represent the wife in this case. My name is David Bodanza, and may it please the court. First, my brother argues that my client asked for a one-year extension, but on page 106 of the record appendix, it should be noted that she simply asked for an extension. It wasn't specified as to 1 year or permanent. And the case law suggests that even if she did ask for 1 year, which she didn't, that the judge has discretion to do either. Secondly, I think what really drills down on this is the definition of abuse in Chapter 209A, Section 1, being one of three things, which are all present here. One, actual or threatened, actual or attempted physical harm. Well, here we have actual harm in that she was bit and she was raped. Secondly, reasonable fear of imminent threat of injury. He threatened to kill her in a premeditated way that the judge noted as bone chilling. And then thirdly, which has already been alluded to, the forced sexual relations against her will. But the case law is clear that where there has been actual physical harm, there doesn't need to be proven an imminent danger of abuse, because we're not on the threat prong of 209A, Section 1. What only needs to be proved is that the party seeking the extension has fear, and that fear is reasonable, which the judge found because of the totality of the circumstances, the horrific allegations, the bite, the rape, the threat of killing, the things that happened subsequently at the airport, and then most recently, him trying to find out where she lived through her youngest daughter, put her in reasonable fear that this man still is seeking contact.
Counsel, just to be specific, do you agree that the judge did not credit the airport allegation or the dog allegation?
Well, not explicitly. I don't think we can say one way or the other. It's certain this judge actually sat on 3 extensions. The initial, the one in February of 2020, and the final one on February 2021. So it's hard to say whether or not he credited the airport or not, or didn't. He certainly didn't say he didn't credit that allegation.
So just to be clear, so it was this judge who, upon request the year before, did not grant the permanent order, but only extended it for a year? Is that what I just heard you say?
Yes, I believe that's correct, Your Honor.
Thank you.
And, you know, we have much being made about the divorce here as a reason for not extending the order. First, it should be noted that the divorce was filed by the husband after the restraining order. The parties were divorced on July 3rd, 2020, by virtue of a separation agreement. That is a written contract that the parties signed and proffered to the court for approval. There wasn't an adjudication, it was a settlement. And in that settlement, it's talks about contact, and it talks about no social media posting and other things, but it makes this point. It says, this paragraph is only designed to respect the privacy of the parties and shall not constitute a restraining order, nor shall criminal sanctions apply in the event of a violation of this paragraph. So clearly we have something here that doesn't do the duty of a restraining order. This would only be a civil contempt, which can take, in our current environment, months to come before the court for adjudication. It is not equal in any sense to the protection of a restraining order, which a violation of a restraining order is a crime, and the police can be called to it. Sometimes when the police come to these things that are based upon multi-page separation agreements, there's no arrest because they say, look, this is a civil matter. You'll have to go to civil court. You'll have to file.
Counsel, just to be clear, that provision is in the divorce decree as a result of the parties agreeing to it. It is not accurate to say that a judge specifically determined that there needed to be no contact.
That's correct. Yeah. The parties agreed to that. And it's typical language in divorce court. They agreed to that. But it wasn't meant to be a substitution of a restraining order. In fact, on July 3rd, when the agreement was proffered to the court, there was an active restraining order that just had issued on February 18th, 2020, and continued to carry forward to the next year of 2021. So I don't think that there's much of an argument that because these parties have a divorce that's done, suddenly means that the wife is not in reasonable fear of harm from this man, particularly in light of the totality of the circumstances and the allegations which the judge credited, and the trying to get the address. I think one of the arguments that was made in the brief was that, you know, there's no need for the order because he moved to California. He's only in Massachusetts 1 week a month. 1 week a month. Well, you know, there's opportunity, certainly, if you're in Massachusetts 1 week a month. And as the judge noted, what's to prevent anybody with a computer and a few dollars from finding another person where they live on the planet? And so we have a very serious situation. Biting, rape, threatened murder. And these things, I think, these premeditated type of things are not the, more mercurial things that my brother mentions that may be common in other cases. These are the insidious, potentially sinister things that demand the protection of the court. And I think the court was justified in doing what it did, certainly. But I think that's the distinction, that because there's been actual harm, that the imminent aspect of physical harm does not need to be shown, says the case law and the statute. It is the serious, it's the fear, objective fear held by the wife.
Counsel, I think we understand your argument. If you feel you've made your points, there is no shame in sitting down, as it were.
Well, if there are no further questions, I think I will sit down. Thank you.
Okay, we are live and recording.
Thank you very much. And good afternoon. We are back on the record in our sixth and last case of the day. It is in the matter of 17 Albion Street Trust, 2021 P660. I just want to assure the parties, first of all, that we have read the briefs. So we are familiar with both the underlying facts and the arguments. So I would urge both sides to cut to the chase to the extent possible. That said, as you will hear, we do have some questions about the state of the factual record. So we will be asking some questions about the facts. But without further ado, I will turn the floor over, I believe, to Attorney Tower.
Thank you very much, Your Honor. May it please the court, Michael Tower from Sanzo McCarthy, representing appellants Jeffrey Bloom and Lauren Chertow. Your Honors, we assert that the lower court erred in ruling that the trust mandates or permits the trustee to divest assets from a separate and distinct irrevocable trust and convey them to someone who is not a beneficiary of said separate and distinct trust. Now, in reviewing the briefing, I'm sure Your Honor saw that Daniel has now conceded in his opposition that at the time the trust was created and the property at issue was contributed to the trust, only two separate and distinct irrevocable trusts were created, one for each of Lauren and Jeffrey respectively. And he has further conceded that one half of the property was allocated to Jeffrey's separate trust and one half was allocated to Lauren's separate trust. Now, as we set out in our briefing, we think that this conclusion flows directly from the language.
Okay, just for the record, counsel, I don't think he will concede that he has conceded these points. So we take your point for whatever it's worth. Can we turn to some of the factual questions?
Of course, sure.
That raise some doubt in my mind in terms of the state of the record. First, in terms of whether or not there are other assets in the trust. Both sides seem to acknowledge at least the possibility that there are some other assets there, although both sides seem to suggest at least that it's not much beyond the real estate. But separately, there's also the question of the life insurance policy, or at least the proceeds now of the life insurance policy. Could you just clarify the state of the summary judgment record on these issues?
Your Honor, the state of the summary judgment record, I think, is best derived from the statement of material facts. The statement of facts submit that that no additional contributions were made to the trust after its initial funding. Now, as I argued in my briefing, Daniel purports to dispute that, but we've argued that Your Honors should treat it as undisputed given the failure to dispute it properly. But if no further assets were contributed to the trust, we believe the record reflects that the life insurance policy was purchased out of the proceeds generated by the property that was initially contributed. And because the equity of that property is indefeasibly vested in Lauren's separate trust and Jeffrey's separate trust, to the extent that property generated income, that remains the exclusive assets of the trust, the separate and distinct trust for Lauren and Jeffrey.
But the judge did not address that issue separately. I mean, you can certainly make your point, as you have, that you don't think that Daniel is a beneficiary at all, but assuming we disagree with that, is the issue of what to do about the insurance policy even before us, given that the judge didn't get into that?
Well, I don't think it's part of the record before you, but if I may, Your Honor, I just want to clarify. Our position is that Daniel is not a beneficiary of the trust only because no additional contributions were made after he was born and he became a potential beneficiary of the trust.
But counsel, even under your theory, I'm even more confused about what to do with the insurance policy, because you say it was purchased with proceeds from the trust, but as I understand it, you're also saying that it was either held by the trust or that the beneficiary of the insurance policy was the trust itself, which suggests that there were that there may have been assets added to the trust.
Statement 5 of the Statement of Undisputed Facts provides, thereafter, the trust purchased a life insurance policy on Richard's life using the income generated by the property held in trust. So if the proceeds were generated by assets exclusively held in the separate and independent trust, the separate and distinct trust belonging to Lauren and Gerald, then the proceeds would stay within their trust, and the use of those proceeds, the assets derived through the use of those proceeds, would also stay within their separate and independent trusts. So unless there were contributions made to the trust after Daniel was born, his separate and distinct trust was simply never funded and therefore does not exist. I'm sorry, am I answering Your Honor's question?
I'm not sure you're alleviating all my confusion, but in any event, on the separate issue, there is an affidavit in the record from Daniel saying that he received payments from the trust, and that does not appear to be controverted. Your argument instead appears to be that because those allegations or those averments were not included in the statement of material facts, they are not properly before us, or were not properly before the judge, and therefore we cannot consider them. But is it accurate to say that he did make those allegations and there's nothing in the record contradicting them?
So certainly his affidavit speaks for itself, and he does allege that he received distributions, and my clients have consistently maintained that they did not receive distributions. I think the issue, Your Honor, is whether or not he subsequently received distributions, we submit is not relevant to the initial question of whether he was entitled to those distributions. Some of these disputed facts we submit are not relevant because the primary question before the court is the interpretation of a document, and that's a question of law to be derived from the four corners of the document.
No, I understand that argument. I'm just trying to figure out the facts first. And in a similar vein, to the extent that there were any payouts from the trust, there seems to be some confusion in the record because everyone appears to assume that, at least initially, there were some payments, but that those stopped after a while. And there are some documents, I believe, from the new trustee saying that, at least by some point, there were no payouts from the trust. And I'm having a difficult time trying to put those facts together in terms of what the summary judgment record established and the extent to which the judge could rely on any statements that the trustee was making in the larger proceedings.
Well, Your Honor, I mean, I will agree that there is some murkiness in the summary judgment record. I am appellate counsel. I do know that after this appeal was filed, there's been significant additional discovery on those issues. But of course, none of that is in this record. And frankly, I'm not qualified to comment on it. I think,
well, frankly, it's one reason why 54B certifications are disfavored. And when you get a state of the record similar to what we have here.
Understood, Your Honor. And again, and I don't mean to belabor the point, but we would submit that the initial question of whether the language of the trust articulates the settlor's intent. And we submit that this court can determine whether or not Daniel is a beneficiary of the trust in general, or perhaps as with regard to the property at issue, based on the four corners of the document itself. And so, although there may be some murkiness in the underlying facts, we would submit that murkiness doesn't necessarily impact this court's adjudication of those issues.
Okay, so your arguments are based ultimately on what you view as the incompatibility between the creation of these particular subtrusts and treating Daniel as a full beneficiary as to the assets that originally went into the trust. But let's try to tease this out. Let's say there were not subtrusts, but only one original sibling. So, but otherwise the same provisions in terms of payouts from the trust would apply. So there are no subtrusts because there is only one beneficiary at the time the trust was created. Wouldn't your same arguments apply in that you're saying that no, these assets were committed in trust and they could have been paid out to that beneficiary? So even though there's an afterborn child, that person cannot be a beneficiary with regard to these assets. And hasn't that argument been rejected, at least by BMC Durfee? So I'm trying to see how the fact that there are subtrusts created really changes that dynamic at all.
So I think the language in BMC Durfee is instructive in this regard, Your Honor, and I would point your attention to the court says at 779, quote, at the outset, the third clause makes a gift of income to, quote, my grandchildren, end quote, with no limiting or qualifying words. So the trust in the BMC Durfee case is a paradigmatic pot trust. And we submit that the fundamental flaw in the lower court's argument and in Daniel's argument is that they also want to treat this as a pot trust. Our trust, however, has extensive limiting and qualifying words after the initial identification of an open class of beneficiaries. Those limiting and qualifying words appear in section 2G, which require the creation of one separate and distinct irrevocable trust for each beneficiary, and then all of the subsequent provisions of section 3, where the settlor went to great lengths over and over again to explicitly state that the trustee is only permitted to distribute assets to a beneficiary from that beneficiary's own trust. So it is indeed the language identifying those separate and distinct trusts and then those dispositive provisions that distinguish this trust from the type of pot trust that existed in the BMC Durfee matter. And so, I apologize.
I'm switching gears here. One of the points you make is that, at least under your view of the facts, the real estate here was purchased with marital proceeds. I'm not sure exactly what you're saying by that in terms of whether or not the first wife was indirectly a settler of the trust, or whether or not, which seems as a matter of law, or that something else applied. Was that fact established on the summary judgment record? And if so, what are you arguing we're supposed to draw from this?
So I believe it is in a summary judgment record. The statement of material facts number 4 says the funds used to purchase the property came in significant part from the proceeds of an insurance loss suffered by Richard and his first wife, Donna Leeds. So I think it's clear that those assets came from marital property. Your Honor, our point in drawing that distinction, and again, sort of without waiving the notion that the court need not consider extrinsic evidence to interpret this trust, is that if you look at this from the perspective that Richard was in at the time the trust was created, the operation of this trust makes perfect sense. The initial contribution of property came from marital assets of Richard.
Not entirely though, right?
Your Honor, the statement does says came in significant part from the proceeds. I'm not aware, nor do I think the record discloses any other source of those funds. But I take Your Honor's point. That's not the language in the statement of facts. But even if it came primarily from those funds, it made sense to set up a trust whereby funds that came from both Richard and Donna would be sort of permanently locked away for the use of the 2 children that they had. As the record reflects, shortly after the creation of this trust, they were separated and then divorced. And so the way the trust is set up is this initial grant contribution of property, which again came at least in significant part from marital funds from Richard and Donna, according to the terms of this trust, was divided into separate and distinct trusts to only be used by the children of Richard and Donna. Thereafter, if Richard had other children with other women, he could make additional.
What if he had another child with Donna?
So the same result, Your Honor. Our position would be that child does not share in the equity in these initially contributed assets, but nothing was stopping Richard from making additional contributions to the trust, from making additional trusts for new children. But as to this trust in particular, it made sense to allow Donna and Richard to put away assets for their biological children while giving Richard the flexibility down the road, if he had additional children, to make additional contributions from funds that did not also belong to Donna. And then those would benefit all of his then existing children, the new children, as well as Jeffrey and Lauren.
But how does that make sense? How does that make sense if they had another child together? I don't see how that makes sense if they had another child together.
Well, there would be a different result for that child. I think on the record, it's pretty clear that this trust was created as they were going through the process of separating. And so I think based on the facts at the time, it was not contemplated that they would have another child, hence the flexibility for future children, perhaps with a different wife. But it is our position that had Richard and Donna reconciled and subsequently had a third child, our position would not change as to the legal significance of the terms of the trust.
Counsel, I have a question. Daniel makes much of the fact that in earlier related proceedings, your clients acknowledged Daniel's status as a beneficiary. And we're going to hear more about that from Attorney Cowan. But my question to you is more pointed, namely, why shouldn't judicial estoppel apply? Specifically, with your clients saying, oh, Daniel has to pay 1/3 of the cost of administering the trust. Why aren't they bound by that?
Your Honor, Lauren's having listed Daniel as a potential beneficiary is entirely consistent.
No, the word potential does not.
No, I understand, Your Honor. I appreciate that, and I apologize for interrupting. At the time that Lauren filed this petition, she had no way of knowing whether, in fact, Richard had made additional contributions to the trust. She was well aware that Daniel was Richard's son. So based on the language of the trust, Daniel was at least a potential beneficiary, and to have left him off, knowing that he is a child of Richard, I think would have been inappropriate. But again, she had no visibility into whether or not there were additional contributions. And I would add, Your Honor, that I don't think that a trustee's subjective understanding of who is or is not a beneficiary can trump the language in the trust itself. So we submit that Daniel was a potential beneficiary, and had contributions been made, he would have been a full beneficiary, since Lauren had no way of knowing that at the beginning of these.
No, but counsel, they specifically asked for a 1/3 contribution towards the fees, I assume, of the new trustee. That's more than a subjective view. That's action.
Well, and if they were assuming that contributions had been made, that would have been an appropriate request. As the case went on and they developed more information and learned that, in fact, Daniel's separate and distinct trust had never actually been funded, that's when the lower court counsel moved for summary judgment in this regard. So often in initial pleadings, there is some uncertainty about the facts that gets resolved as you go through the process. That's exactly what happened here.
Okay. Do either of my colleagues have any questions?
So this theory of potential beneficiary was developed over time. That's what I hear you say.
I don't know that I mean to say that it was developed over time. I believe I'm saying that when the petition was initially filed, they didn't know if he was a beneficiary or not, but because
but they included him as a beneficiary. Notwithstanding, if you even taking what you say is true, they included him as a beneficiary.
Because he's a child of Richard, he would have had a separate and distinct trust had his trust been funded. And so without there having any information about whether that trust was funded, again, I think it would have almost been misleading to the court to pretend that he wasn't Richard's son.
Just semantics. You use the word potential beneficiary. I mean, is technically, isn't he a beneficiary of this trust, but just it does not receive any benefits from it because of the way it was structured? I mean, he's a further born child of the settler, so he's a beneficiary of the trust. It's just your position is there's nothing that he gets out of it.
Well, and it may be a semantic distinction, Your Honor. My understanding from the case law is that you cannot have a trust without a race under these types of circumstances. And so since Daniel's separate and distinct trust wasn't funded, in effect, there is no trust. And so it doesn't seem accurate to call him a beneficiary when we're saying that his trust never actually came to existence because it was never funded by the grantor or based on this record by anyone else.
Okay, thank you very much, counsel. We will hear from Attorney Cowan.
Good afternoon, Your Honors. Attorney Marley Cowan for the appellee Daniel Krasicki Bloom. May it please the court. I do think it's important for this court to note that, as Judge Moriarty pointed out in her memorandum of decision, this creative theory set forth by the appellants is a theory that was constructed in order to further advance their ability to have unanimity among the trust beneficiaries in order to direct the trustee to pursue a superior court action against their stepmother, Daniel's mother. As we were just talking about, it should not be lost on this court that the arguments set forth by the appellants were not even thought of for the nearly entire 40-year history of the trust. As we just discussed, Lauren herself acknowledged that Daniel is a beneficiary. Nowhere is there noted that she is a potential beneficiary or he is a potential beneficiary or any other qualifying references to Daniel being a beneficiary. Similarly, in the petition for instructions filed by the trustee noted that Lauren sought to have the burden of the legal fees borne equally by the trust beneficiaries, including Daniel. Thus, the backpedaling now that Lauren only included Daniel because he was a potential beneficiary is just an excuse to cover these prior admissions.
Okay, if Daniel said, to be precise, counsel, you did not, unless I'm missing something, raise a judicial estoppel argument as such.
That is not in our brief. That is correct.
And so hasn't that argument been waived on the theory that waiver itself can be waived?
We do make the argument, though, Your Honor, that where there are admissions on file regarding a central issue of a case, that summary judgment is proper, and that is raised. At the very least, summary judgment to be granted to Jeffrey and Lauren and on the exact opposite premise of a prior admission is inherently wrong and unjust. Nevertheless, we do find ourselves here today arguing as to whether or not the four corners of the trust document is unambiguous as to the grantor's intent to include all three of his children as equal beneficiaries under the trust. As ruled by Judge Moriarty, it is unambiguous that the grantor intended for Daniel to be an equal beneficiary of the trust. In order to determine the grantor's intent, we need to look no further than paragraph 2D of the trust, which states, the beneficiaries of this trust are Lauren Cheryl Bloom and Jeffrey Robert Bloom, the children of the grantor, plus such additional children of the grantor born hereafter.
Okay, so can I just, I mean, it is clearly unambiguous that Richard intended Daniel to be a beneficiary, but you inserted the word equal in front of that. What establishes an unambiguous intent of, if you will, equality? Or are you instead saying that if there's ambiguity about whether the beneficiaries are to be treated equally, then as a matter of law, we presume they are to be treated equally unless there's a specific contrary intent expressed?
My argument is that it is unambiguous that the grantor intended for Daniel to be an equal beneficiary, and I'll further elaborate on that point. But on your second point, in the event that this court finds that the trust document is ambiguous and you cannot determine the grantor's intent from the four corners of the document, then we submit that this case should be remanded back to the probate court for further fact finding. And so to answer the question about—
Can I probe you on that?
Please.
Why? Maybe I'm wrong, but I thought I had offered you a life ring as a matter of law, that you could say that ambiguity, there are different ways to resolve ambiguity. One is through extrinsic fact finding, another is through legal presumptions. And I was questioning whether or not one could apply a legal presumption that if the trust documents are ambiguous, as a matter of law, that gets resolved in a particular way. Are you disavowing that argument?
No, Your Honor, I know exactly. I think you know what you're talking about, which is that when you have an open class of beneficiaries, such as what we have here, the presumption is that the intent is to benefit all of those beneficiaries, and the class remains open. And as I further cite in the brief with regard to the separate shares, the separate subtrusts that were funded for Jeffrey and Lauren, those were subject to divestiture, and they were subject to reduction by the entrance into the class of afterborn children. That is the intent of the grantor, is that his children, as they came into the class, that they are treated equally. As we were discussing earlier, if Donna and Richard had reconciled, the grantor's intent would not have been that those children of all from the same marriage would be treated differently. There's nothing in the trust document that leads anyone to conclude that. There's nothing in the trust document talking about different points of birth or different points of contribution. He made this trust to benefit his children no matter when they were born.
You also argue prior to any remand that if there is ambiguity in the trust, that we can look to extrinsic evidence.
That would, yes, Your Honor, that is my argument. Certainly, I understand from my brother counsel that he is hesitant and argues not to consider extrinsic evidence. However, the fact remains, as Judge Moriarty noted, that Daniel did receive distributions from this trust, as did Jeffrey and as did Lauren. And she did not err in referencing those distributions. She was just simply confirming the fact that her interpretation of the trust, that it's unambiguous, did not fly in the face of how this trust was actually administered.
Okay, but given counsel's argument with regard to the statement of material fact, what allows the judge to consider the affidavit from Daniel that was submitted, at least on this point?
As I just stated, Your Honor, I think that her decision did not rely on extrinsic evidence. It was just more of, I believe it was more of a sort of an anecdotal reference, just the fact, showing the fact that her interpretation was not contrary to how the trust was administered. The reference to the extrinsic evidence was very minor, considering her entire interpretation. She's the one who pointed out the fact that, again, if there were children all of the same marriage, that they would be treated differently. And more importantly, she even said that there would have to be something more in the trust to show that the grantor intended that his children be treated differently depending on the time of a contribution. And that's just cannot be.
Let me make my question a little more pointed. Do we, as an appellate court, have a basis for considering Daniel's affidavit on this point where the allegation was not included in the statement of material fact?
It was, I believe, as we were discussing earlier, it is not contradicted by Jeffrey and Lauren. So yes. I'd also like to point out to going back to the open class of beneficiaries. The restatement tells us that a disposition is presumed to create a class gift if the terms of the disposition identify the beneficiaries only by a term or a relationship or other group label. In this case, children. Jeffrey and Lauren are specifically referred to as children, therefore creating the entire class of children. This class could only close if the trust was terminated, which it was not, or once the grantor could no longer have children. In other words, the class only closed after the grantor's death because he could no longer have children. When you have this open class of beneficiaries, the interest of then existing beneficiaries is a mere expectancy and subject to divestiture. In other words, the Jeffrey and Lauren's future interest in the trust were only theoretical opportunities for future gain of property subject to the entrance into the new class of additional children. I'd also like to refer to the prior case we were just talking about, the BMC case. There was the controversy between the children born prior to the testator's death and those born after the testator's death in determining which grandchildren of the testator was entitled to receive income. The court found in that case that the afterborn grandchildren were entitled to income. The court stated that the income interest of each grandchild living at the time of the testator's death would be vested, even though the bequest would open from time to time to let in other grandchildren as they were born up until such time that the class closed.
But counsel, Attorney Tower does point to some language in that trust, which can be read at least as limiting it, saying that there's nothing else in the trust agreement that suggests a different intent. And his argument, as I understand it, is that that intent is laid forth in the subtrust provisions and the distribution provisions that, as you know, allow distributions during the life of the trust.
Yes, and so I think it's useful to look back at those provisions. So the provision that talks about the income distribution, that references the specific subtrusts. But if you look at the distribution provisions for the principal distributions, that actually references this trust as a whole, doesn't reference the separate subtrusts. Similarly, paragraph 2G, 2G references that the trustee may handle the mingling and bookkeeping of funds for the several trusts created. There's really no reference throughout the trust document to both trusts or two trusts or either trust. It's a lot of references to several trusts created herein. And also pointing to paragraph 5M of the trust, this is what gives the trustee the power to actually divest the shares created for Jeffrey and Lauren in order to appropriately fund Daniel's trust fund once came into being and once he was born. In the
can I just help me understand the issue regarding the insurance policy? As of just a factual matter, do you concede that under the summary judgment record, it's established that the insurance policy was purchased from either principal or interest from the trust?
Your Honor, that is not a fact that has yet been fully vetted through discovery, but I recognize that that is what we need to live with in the summary judgment record.
That what?
That the statement of the material facts and that the life insurance, that their only contribution to the trust was at the time the trust was created.
But was it purchased with principal or interest, or do we know?
I don't think I can answer that for you today, Your Honor. I do not know the answer. And I'm not sure if the discovery has been fully completed on this point because this happened 40 years ago. And this is a subject of discovery in the ongoing Superior Court case.
Because I'm trying to figure out that, were we hypothetically to rule in your client's favor with regard to the larger issue, has that thereby resolved that the life insurance policy is now part of the trust that gets split 3 ways? Or have the other two preserved an argument that this was purchased through income that should have been distributed to them prior to Daniel's birth, and therefore they are entitled to the insurance policy separate from the larger issue of whether or not Daniel is a beneficiary?
Honestly, I'm not sure I can answer that for Jeffrey and Lauren as to what their position is. The main controversy in the Superior.
I have a feeling I know what the position is. I want to know what we should do with that issue in this appeal.
Your Honor, I mean, respectfully, I do think that it's I understand what the importance and the relevance, of course, of the facts, but we are looking here at the 4 corners of the trust instrument to determine is Daniel an equal beneficiary? And then the determination of what each beneficiary is to receive or what they're entitled to receive, that's a question for another day. And I would say that in the event of an adverse ruling against Daniel and finding that he is not a beneficiary would create a sort of a calculation mess, because he's already received distributions from the trust. We're going to have to, and a lot of that happened when he was a minor. So we're going to have to sort of untangle all of that. And this actually goes to my broader public policy argument that I've raised in my brief, in that often Massachusetts trusts are drafted to create subtrusts for an open class of beneficiaries. Drafters are seeking to blend the benefits of a family pot and a separate shared trust method to benefit both.
Can I drill down a little bit on that? Why do people create subtrusts? Is it largely because of the tax benefits or perceived tax benefits or sheltering, or is there some other reason?
Well, I'm sure there's a multitude of reasons, Your Honor, but I would venture to say that a lot of it is for just ease of administration to create these subtrusts.
It seems like that cuts the other way, but.
Well, for ease of administration, but then there is, so for example, in this trust, income is to be distributed out to the beneficiaries. So let's say before Daniel was born, to Jeffrey and Lauren, to distribute income to them. That is determined, that the rule of convenience also that I cite, in that temporal moment in time to decide whether or to determine the beneficiaries in existence at that time. So if the trustee decided to separate them into subtrusts, then that would make it easier. But for the principal distributions, though that does not occur until later in this trust. And so having an adverse ruling against Daniel in this case would render these afterborn children and afterborn grandchildren, descendants in all of these Massachusetts trusts in limbo. And I argue it would open the floodgates of litigation to try to figure out who is actually the beneficiaries of these trusts. And I would submit to this court, Your Honor, that drafters and creators of these trusts that include afterborn children, they do not want their afterborn children to be treated any differently unless it was explicitly stated so.
Okay, just a question on your rule of convenience. You seem to be saying, tell me if I'm wrong, that to the extent there were distributions from the trust before Daniel was born, those are gone. Your client is not asserting any rights for that property.
Correct.
But let's say that notwithstanding the terms of the trust, that income was supposed to be distributed to the beneficiaries annually. Let's say that wasn't done before Daniel's birth. Under your rule of convenience, does Daniel have a right to the money that was not distributed but should have been, or well, you understand what I'm getting at.
I do understand what you're saying. Based on the terms of the trust, income is required to be paid out. So of course, I don't want to concede anything or take the position of Jeffrey and Lauren, but if income was to be distributed out to them and wasn't, then they would certainly have an argument to be made. But at the same time, Daniel may have a counter argument to that, and we just haven't gotten there in this case yet.
And are those issues subsumed within the present appeal or not?
Just to clarify, the issues of
what happens to money that should have been distributed but that was not?
Yeah, I understand your question. No, I do not believe that is a subject of this appeal, and I don't think we have gotten there in the case, even as it's proceeding in the Superior Court, because the question of distributions to whom and when that happened is still very much a subject of discovery.
Another reason why God hates 54B certifications. Do either of my colleagues have any questions? Hearing none, very interesting case. We will obviously take what we have and do our best to resolve it correctly and quickly. In the interim, if your clients have any free time, I recommend that they read or reread Bleak House, which is still the best book on the subject of inheritances and fights over them and what happens often in the end. So,
I'm sorry, Your Honor, what was the name of that book? I missed that.
Bleak House by
Bleak
Charles
House.
Dickens.
Thank you, Your Honor.
The case of jaundice versus jaundice. And with that, we